Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring
relevant.
the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican boys, service club.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict.
Hello.
Hello.
Matters, and unfortunately, you have not.
All right, we got to turn this down just a little bit. I love my grandkids. Thanks for the laughing disco ball. Appreciate that. Let's see. Who was first in chat today? I have no idea. I don't know who it is. I don't know. We'll find it eventually. All right, we've got a couple things to do really quickly. I'm not sure if I can read all this in time. Let me see if I can. Let's turn the music down just a little bit. All right, let's see. Publish summaries of opinions from the Supreme Court of Georgia. Let's see, state view phase on. Yeah, no, that's not. Oh, let's change the view a little bit. Here we go. Let's go to this, shall we? Summary of opinions. This is dated today. Today, phase on. Yeah. Let's see. Payne v. the state of Georgia. Payne v. the state. This is the one we want to read really quickly. The Supreme Court of Georgia has vacated the Clayton County Superior Court's denial of Hannah Payne's motion for a new trial in her murder case. Vacated their denial of her motion for a new trial. Doesn't mean she gets a new trial. And has sent the case back to the trial court with instructions that it issue a new order that does not contain citations of fake cases or other misattributed case citations. In response to Payne's motion for a new trial, the assistant district attorney assigned to the case, Deborah Leslie, filed a brief that contains non-existent cases and cases that do not stand for the proposition asserted in the brief. Today's opinion, authored by Justice Benjamin A. Land, states in an order largely prepared by ADA Leslie, the court trial denied Payne's motion for a new trial. That order also contained citations to non-existent cases and misattributed citations. The state's brief on appeal, also signed by ADA Leslie on behalf of the Clayton County District Attorney's Office, also contained citations to numerous cases that do not stand for the proposition asserted. While we have no rule against the responsible use of artificial intelligence software by attorneys, citing cases that do not exist or do not support the proposition for which they are cited is a violation of this court's rules and falls far beneath the conduct we expect from Georgia lawyers, Justice Land writes. Therefore, the Supreme Court has admonished the Clayton Judicial Circuit District Attorney's Office and ADA Leslie, who represented the state in Payne's case, and has suspended ADA Leslie's privilege to practice law in the Supreme Court for 6 months. Only in the Supreme Court. As a condition of the reinstatement of such privilege, ADA Leslie must obtain and certify that she has completed an aggregate of 12 hours of continuing legal education beyond the hours regularly required to maintain active membership in the State Bar of Georgia, consisting of sessions on ethics, brief writing, and the proper use of artificial intelligence software in the legal system, today's opinion states. In the underlying case, Payne was convicted of murder and other crimes stemming from the 2019 shooting death of Kenneth Herring and was sentenced to life with the possibility of parole for malice murder, plus additional consecutive years for other charges. On appeal, Payne argued that her trial counsel rendered ineffective assistance by failing to seek jury instructions on citizen's arrest and by failing to seek an instruction on defense of others. Payne contended that the jury in her trial was instructed that her attempt to stop Herring, whom she believed was an impaired hit-and-run driver, was unlawful unless she was acting in self-defense, and was never instructed that it could acquit her if found her to be acting to defend others or arrest the driver. While Georgia's citizen's arrest statute was repealed in 2021, Payne argued that the repeal was not retroactive and so should be applicable to her defense. The state argued that decisions by Payne's trial counsel do not not to request a jury instruction on a citizen's right to arrest or instruction on defense of others were reasonable, and the Payne had not shown that these decisions affected the jury's verdict. The Supreme Court heard oral arguments in this case on March 18th. A couple days following oral arguments, the Supreme Court ordered the counsel for the state to file a supplemental brief explaining the errant's case citations, and she filed a supplemental brief which basically deleted all those references and just had all the rest of it in. She did say that she used AI and didn't check it very closely, and it doesn't talk about the Payne's case other than that. But be careful. Be careful with your AI, people. We're not going to read the full thing because we're running out of time. We're going to be back in court here in just a minute. So that's the update for Hannah Payne. This is the Stefon Diggs trials. Yes, actually, I need to put that on the screen really quickly. Where's our chat? There it is. Ding. All right, we're going to be going back to court here in just a moment. So buckle up. It has been a crazy morning, and we've actually, the state has rested, the defense has rested. We have closing arguments coming up. Closing arguments, jury instructions, then verdict watch in this one. She should be forced to go back to law school or elementary. I know, start lower. Man. Mathis, thank you, by the way, for those files. They're asking for something to review that's not hopeless garbage. Yes. Briefs or boxers? Always briefs. Legal briefs. Just kidding. Should be short deliberation. Don't forget to like the stream when you come in. We had, 2 weeks ago? We had a 14-minute verdict. This one might be faster. Just putting it out there. If we get there, it's going to be faster. Can you imagine how much money Diggs has lost with his allegations, civil suit incoming? Maybe. But apparently, if she doesn't have enough money to find an Airbnb in Atlanta, she probably can't pay for the civil suit either. You can't squeeze blood from a rock. Or from a turnip, for that matter. Any car buying update? No, we have not bought a car yet. You think we can get a 10-minute verdict? 1 hour tops for verdict. It's been quick. It's been quick. I'm invested. Yes, we're gonna be going back to court here in a minute with instructions. It is 2 o'clock straight up right now, which is when the court said we would be back with closing arguments. But we've had many a sidebar and many a break today as well. How's your granddaughter, baby girl? She's doing fabulous. Get to see her a little bit on the FaceTime. Can't wait to see her in person. I am today regretting drinking the Mountain Dew that I drank last week. I have got a killer headache from caffeine withdrawals. So we're just going to fight through that. They go away after like 3 days, so it should be good. $2K per week with housing is a pretty good gig. Yep, for sure. Gesundheit. Sorry. That sneeze just crept up on me. How's your shoulder and back? Great. Thank you for asking. So much better. It's almost all the way better. Let's see. For making hot dogs, yes. Microwave hot dogs with a little bit of mustard. That's all we need. Makes the world go round. Let's see. We're going to Cam 7, right? Yeah, I think it's 7. There we go. This one. Mary, no, I'm good. Thank you. Corn dogs are better. Yes, they are. 100%. I'd vote guilty until pizza came. Holding off for a little free food. Dr. Pepper Johnsonville brought for lunch. I saw those in the store. I have not, obviously, I've not tried them yet, but I do love a good Johnsonville brat. Obviously, I like them when you're cooked on over flame. It has to be over flame. You can't cook them over like just like a hot plate. Brats need fire. They need fire.
In the jurors, anything we need to address?
There we go.
Maybe we've seen it sidebar.
Yes, of course.
Of course. Let's start with the sidebar. Okay, here's the quote from the handyman. $1,000. $1,000. 3 pieces of wood and a bucket of paint. And they're on business again. The beeping you hear is the "we're muted" sound to let you know that the sound is still on. Otherwise, people would say, "Hey, no sound. I lost sound. What's happening?" We're still here. It is also somebody's heart rate monitor. That's just a matter of convenience. We just plugged into somebody, or random person at the hospital. So that's good. Some pretty tight braids he's got. It's pretty impressive. Also not a sponsor, but yes, I agree. I can only eat hot dogs burnt on the grill. You don't do the microwaved until they look all shriveled and dry. Option. What about boiled hot dogs? Nope. Because then you're left with hot dog water, which is basically it's terrible. It's like I would sooner hand stir a pot of nuclear waste than have to deal with hot dog water. Now we're in the hospital. We have migrated right next to the patient's bed. We plugged directly into the heart monitor. Oh, we moved away again. Microwaving puts off gases from hot dogs that are not healthy for you. Well, the problem is the hot dogs are also not healthy for you. So it's a little, it's one or the other. Will the camera person check out the watch again? Is that you're on your bingo card? After lunch watch check? I'm sorry, MJ. All beef hot dogs are the only way to go. I prefer them, but they're not much better. As if you dare, I should say, if you dare to look at the ingredients, they're not much better. It's the same parts from a different animal. That's how it ends up. OG Sean White, welcome to the gallery, my friend. Thank you. Hope you're doing great. Good to have you here. Congratulations on your live stream. I'm gonna keep trying to check in when I can. Wiener water soup. Oh, yuck. Can you imagine starting with hot dog water and just adding a few potatoes and some celery and I guess that's it. You know, I don't know what else you want to ruin by putting it in hot dog water. Oh, no good. Is the heart rate a bit slow? Yes, they're on their last legs. This is so gross. So if you're in no on hot dogs, where do you stand on spam? Spam, 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 spam. Not a big fan of spam, but I'll eat it on a campout if it's fried. It has to be on a campout because there's no other option then. And I also do like haggis, so there's that.
Your attention, all right.
Zoom in on the ceiling. I think that's a false ceiling, like the acoustic tiles on the ceiling or something. It's that, or we've zoomed in on the surface of the moon.
Maybe seated.
All right, jurors, good afternoon again. As I told you, the evidence in this case is closed, and you're about to hear the closing statements of the attorneys. And what I want to say to you about that is that this is an important part of the trial because it is the final opportunity given to the lawyers to address you. It's an opportunity for the attorneys to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you are about to hear is not evidence. Lawyers are not witnesses. All the evidence in this case has been presented through the testimony of the witnesses and the exhibits, which you will have an opportunity to examine and consider during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or disfavor either side. For example, the attorneys are not permitted to refer to facts that are not in evidence in this case. If based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal belief in the credibility or lack of credibility of any witness who testifies in this case.
Oh, good. We've seen that before, too.
That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If you become conscious of any passion or prejudice as you consider the evidence or engage in your deliberations, you must put those feelings aside and not permit them to influence your thinking. And if a lawyer makes such a comment, you must disregard that comment.
Better proceed. Bless you.
All right.
Good afternoon again, ladies and gentlemen.
Defense goes first.
As I said to you in my opening statement, there was no assault, no strangulation, no incident at all on that day or any other day. You didn't see any injuries. You didn't see any photographs. You learned there were no medical records, no statements, no nothing between December 2nd and December 16th. You have not been provided with a single shred of credible evidence to determine that any assault actually occurred in the house on that day. The Commonwealth's case is nothing more than the words of Miss Adams. In my opening statement, I told you one tool to use as you go through this process is to consider how to find the truth. That the simplest answer that accounts for all the facts, that answer is the truth. And so what I want to do is take you through some of the undisputed facts in this case. December 2nd, Ms. Adams spent the afternoon talking on the phone. She got a ticket to Atlanta. She cooked Stefon Diggs dinner. We learned this morning that it was a hot dog. She went into Mr. Diggs's bedroom to provide him birthday presents and to deliver those birthday presents. Timeline-wise, all of this, every single fact that I just mentioned, all of those would have occurred after what Miss Adams says was a violent assault that occurred sometime that afternoon. That night, Miss Adams left the house at 7:15, and she flew to New York City. You heard that she told the police that she stayed with friends. You heard her describe whose friends they were. But you also heard her say that she had a ticket to Atlanta, purchased before she ever changed it to go to New York City. You saw videos of Miss Adams when she arrived in New York. You heard from the woman who picked her up from the airport, who also saw Miss Adams when she arrived in New York. You saw video and heard from Tali Moses, who spent the entire week with Miss Adams in New York. And you got to see how she looked. You got to see her face, you got to see her neck, you got to see the way she moved during the course of that week.
Thank you, Sean.
One thing I'll say about that, Miss Adams, she might define bruising, however, is expedient or convenient for her, but we all know what bruising looks like. You saw the videos, and you heard from the witnesses. On December 5th, Ms. Adams texted Stefon Diggs, "Hi, can you please approve my pay with finance, please and thank you." That would have been 2.5 days after he violently strangled her in her bedroom. December 6th, you saw the video of her dancing. That's 3.5 days after this assault allegedly occurred. You heard that throughout the course of that week, from December 2nd to December 9th, Miss Adams didn't mention a single thing about any assault to anyone. The one thing you heard her mention was on the afternoon of December 2nd, she told Shy she wasn't going to Miami. You heard that on December 9th, she went back to the house. And I told you the details were going to be important about her going back to the house in my opening statement. She got back to the house at 11:30 p.m. alone and walked into the house. And what did she do? She didn't just go to Stefon Diggs' bedroom door and knock on it. She tried to punch in the code, and it didn't work. And those are her words. That's what she told you. None of that is consistent with a violent assault having occurred the last time they interacted with one another. Not one piece of that. And those are undisputed facts. On December 11th, Miss Adams texted Mr. Diggs her apology. She said she was sorry she was being emo, and she didn't want him to feel that way. She didn't want him to think she was trying to quit her job. And she told you she was trying to keep her job. She was trying to get back. She also told the police 5 days later, that she had quit her job on December 2nd. We know that that was a lie. Not just from the fact that she actually told you that that was a lie, but from the actual evidence that you have in this case that is undisputed. That evidence goes on. She told Mr. Diggs' girlfriend that she didn't say any of that to the police. Meaning what she told the police, that she didn't accuse Mr. Diggs of assault. And that wasn't true. She also, a month later, told the world that she had never demanded money. And that also wasn't true. Now, more undisputed facts. Miss Adams was paid for November. At first she didn't admit that. She ended up saying they worked it out. She got paid for 2-3 weeks. And we actually got an answer today on why she wasn't paid for a full month. Because she was in Tobago with Shy Charles. You heard from Melissa Goddard. Miss Adams was paid up. The non-disclosure agreement. Miss Goddard talked to you about that. And you heard about that from Miss Adams. I want you to look at the text message in Exhibit 4. It's on page 195. We talked about it a little bit yesterday afternoon. But this is another undisputed fact, and it's very important. Because, despite what Miss Adams told the police on December 16th, and told you at times yesterday, on December 13th, 2025, Miss Adams says what she thinks the NDA is about. And she says, "You sitting here playing in my face, 700 comments. If I told someone why it's not in the blog, you believe it," meaning Mr. Diggs, "and now sign an NDA. Send me my money. You sitting here playing in my face." Miss Adams wants you to believe she wouldn't tell Shy Charles because Shy Charles knew Mr. Diggs. That requires you to completely ignore the fact that she chose freely and willingly to go to New York to stay with Shy Charles. December 13th, she told Mr. Diggs, she told Stefon Diggs what she thought the NDA was all about. And it was about the blog issue. You think it might make a little sense if the NDA was about any kind of a physical assault, a strangulation? That she might say to him anything. "Hey, you know what this NDA is really about." Or maybe just, "The NDA, because you assaulted me?" Not a word. She describes why that's there. And those are her words from December 13th. And that is undisputed. Now let's talk about the police for a few moments. Because Miss Adams went to the police, as you heard, on December 16th. And there's other undisputed facts in this report. She lied to the police. She did not leave her job. Miss Adams told you something yesterday where she said, "Well, I left my position was like in the house, but that wasn't my job." And you heard what Officer Ellis said this morning. I said, "You mean her position, as in her job?" And he said, "Of course." She told Officer Ellis that she just went back to get her stuff. And you know that isn't true. And at times, she seemed to admit that that wasn't true. And you know from her own words at the time to both Mr. Diggs and to Sonny that that wasn't true. The text message that you've heard about the deletion. There's two things that I want you to pay close attention to and that I want to talk to you about in both Exhibit 1 and Exhibit 2. Exhibit 1, the text message that she sent purporting to be a screenshot of the argument that led to a violent assault that ended with Mr. Diggs choking her. That's what she told Officer Ellis. And you heard that from him this morning. You also heard from her that she deleted messages. And I think what she said was something like, "I didn't want to look bad," or something along those lines. And if you look at what was actually deleted, the words she said, she was saying bet and pussy were what she deleted. That's what she did. She did delete those messages, right? Those are not in the text messages that she provided to Dedham police. But more importantly, what she actually deleted that wasn't about making her look bad or not, it was right after the words, "I'm out of your life." And it said, "and ruining that bitch life." And then you can actually go to Exhibit 2 and look, there's a fairy emoji she sent. And why that's important is because, as you heard from Officer Ellis this morning, it'd be important to know if somebody deleted messages. It'd be important to see the full picture. And that message right there, and ruining that bitch life, apologies for the language, with the fairy emoji, you think that might have prompted the question, hey, who's that bitch? She answered the question for you yesterday. It was Lindsay. The argument wasn't about money. You have it in evidence. And Miss Adams later admitted that. These lies to the police, the fact that they're undisputed, why? Look at all of those facts. They're undisputed in the record. They are all there. If you remove from those facts one thing, that an assault occurred, they all make sense. If you plug in that she was assaulted that afternoon before all of this happened, before everything I just read to you, none of it makes sense. Why would a person who is just strangled go down to the kitchen, chat on the phone, and not have a single mark on their face or look even remotely bothered? Why would that same person cook dinner for the man who just did it? Why would that same person knock on his bedroom door and deliver 2 birthday presents? Why would she act the way she did for the next week? And then why lie about it repeatedly to the police? And what ended up happening next, just chronologically, gives away the game on that. Because what you heard is that only a couple weeks later, her mediator made a demand for money. And if you plug that fact in, now it all makes perfect sense. We have provided evidence to you. We have presented evidence. We have called witnesses. As I said, we're doing so in order to give you the fullest picture of December 2nd and of what happened or did not happen. And think about that for one moment. How do you prove a negative? It's basically impossible, right? Pick a day, 2 months ago, account for every action that you did on that day. Every moment of your day. Great, now prove it. Can't be done. And this trap, the framers of our system, they were aware of it. And that's why it works the way that it does. The burden is on the Commonwealth to prove their case. And their case, as you have seen, is the internally inconsistent testimony of one witness.
Hot dog water, that's what
and
it
that is their entire case. And that is not enough to meet their burden. The burden that you are going to hear is reasonable doubt. And the judge is going to tell you that that's to a moral certainty. How much would you bet on the words of Jamila Adams? Would you bet your own life? Someone else's? You have all of the tools in what I just laid out for you to make a credibility assessment. But it is not only that. Because the other thing the judge is going to tell you is you can actually take into account the way the witness answered questions, behaved,
didn't.
their demeanor, how they looked. Did they sound consistent? Did the things they say actually at least stay true internally in their own story? And one example I'll give you on that is this morning, when Ms. Adams was asked about another monetary demand. She didn't answer the question. She couldn't. She wouldn't. She gave you multiple excuses. She tried to say attorney-client privilege, and when there was no response to that, she said, I can't answer that correctly. Take the way she answered questions into account, but line it up against the facts that you know that you have. Because that's how you got to make a decision. On facts, on evidence. In terms of the evidence that the Commonwealth has actually presented to you, what they have presented to you are the claims of one person. Their second witness undermined their first. And there's a reason for that. There's a reason they had absolutely nothing to corroborate this allegation, which, one thing I will say about the assault and battery, she described Mr. Diggs slapping her on the right side of her face with his right hand. And she actually demonstrated it for you. But the problem is that's a physical impossibility. And the reason I would suggest to you that that demonstration didn't go quite well is because sometimes people miss their mark. Sometimes actors forget the script. What you do not have before you is anything that you can base a firm decision on, unless that decision is that the Commonwealth has not proved its case. The Commonwealth has an opportunity to speak to you after I do. And you heard the Commonwealth question some witnesses about working for Mr. Diggs. There's a number of people who were called as witnesses. We tried to be as quick as possible. It's not terribly exciting to hear a witness talk about how they heard and saw nothing. But for a moment, stop and think and ask yourself, if you were accused of having something happen at your house on some random day 3 weeks ago, who would be there with you? The people closest to you. It'd be your family. The people who are in your house all the time. And for Mr. Diggs, we talked about that. That's staff. That's Miss Salas. That's all the people that you heard from. One thing that I want to talk about is a reason for bias. Because when Mr. Virtue asked, I think the first witness she was Miss Salas. Mr. Diggs paid her salary, isn't that right? The one witness who has the most significant financial interest in this is Jamila Adams. You heard her talk a lot about money yesterday. And that was the Commonwealth's only witness to even touch on what they claim this assault was. That's their evidence. They cannot, and they have not, proved this case because no assault occurred on December 2nd, or as I said, any other day. And it's your obligation to hold them to that burden and to decide the case on the evidence that you have in front of you. And that evidence provides one answer alone. And I would suggest to you that is that Miss Adams made this accusation as a means of trying to leverage and humiliate and to punish Stefon Diggs. And you heard that he has been living with this case and these accusations since December of 2025. And it is time to end. The evidence that you have heard, that has been put before you, is not enough for the Commonwealth to sustain their burden. It is your obligation to return a true and a just verdict. And the evidence that you have heard requires that you go back into that room and that you lift this burden off Mr. Diggs' shoulders and that you tell him and the world that Stefon Diggs is not guilty of this incident that never occurred. Thank you.
This took about 20, 23, 24 minutes.
Good afternoon. Feels like it's been a little while since last time I talked to you guys directly. So, was Miss Adams a perfect witness? No. She was argumentative, avoided, difficult. But does that mean you should throw away everything she says? She said? No. I think it'd be easy for you guys to do that, but that's not your job.
2, 3, 4, 5, 6 right now.
You guys are the jury. It's your job, your sacred duty, to comb over every bit of evidence you heard, to consider it, to give it the attention it deserves. The attention, the scrutiny, the weight it deserves. You don't have to like Miss Adams. You don't have to like the way she testified today and yesterday, but you do have to give her and her testimony the attention it deserves. You heard from her about what happened in that room on December 2nd. She said he entered the room, slapped her, put her in a headlock, said some things to her. I suggest if you remember how she was testifying, I think the way she was testifying to that lends some to her credibility. She was taking her time. She was looking. She was trying to remember things. As the defense counsel predicted, one of the things I'm going to say is that Miss Adams was the only witness you heard from about what happened in that room. You have defense's witnesses who said what happened afterwards, but if you remember Miss Adams' testimony, she said that was after she had an opportunity to kind of put herself together. She said she cried, she changed her clothing, she kind of started packing. The question you may be having is, why would she act that way? Why was she going out and smiling? Well, I'd suggest to you that all the people she was around are people that have known Mr. Diggs much longer than they've known her. I suggest you even consider the relationship she had with Mr. Diggs. He was sometimes lover, a boss, landlord. He was a athlete, a celebrity, financially powerful, surrounded by people that were all on his payroll that liked him. That when you put that all in consideration, her behavior does make sense in that it was her way of continuing on past that. And she told you that they had a complicated relationship. She said they argued all the time. So that might also make sense as to why she texted them afterwards saying, hey, trying to make amends or trying to figure things out, why she gave the birthday present afterwards. In this case, you heard 4 kind of things, right? You heard things that weren't evidence. The openings, these closings, questions, things that were stricken, those are things that aren't evidence. They can kind of give you some context, but those aren't the evidence in and of themselves. You heard the actual evidence. That was the testimony from the witnesses, the videos, photos, and you'll be able to see also all those text messages. The third thing you're going to hear, so things that aren't evidence, things that are evidence, and the law. The judge gave you some preliminary law at the start of the case. She's going to now, once the closings are done, instruct you on the full law. I ask that you give her the same attention that you've given to all the evidence, and you've given the same attention to both attorneys during their closing. You give the judge that attention when she reads the law. And there's a fourth thing that you're going to need to pay attention and listen to and consider, and that's each other. When you guys are done here, once I finish, once the judge reads the law to you guys, it'll be your job to go into that room and deliberate on this case. When you go in that room, it's up to you guys how you want to run it. There's no manual, there's no guide, there's no schedule of how you guys are going to come to your decision and reach your verdict. And no one is going to make sure you're doing it one way. What I would suggest you guys do, and you guys can do whatever you want, this is just my suggestion to you. What I suggest you guys do is you don't go in there and just say, all right, let's take a poll right off the bat. I suggest you guys take the time, go over all the evidence, go over each witness, talk about each witness, try and do it both ways, back and forth, for every witness, not just the Commonwealth's defense as well. Go over every bit of evidence. Really take the time that this case deserves. And also listen to each other. I'd suggest as much as you can, make sure if there's someone that's that's not saying anything, make sure you get to hear from them as well. As I said at the start of this case, that every bit of evidence is important, and that's true. I'd hope that if you guys fairly treat every bit of evidence the attention it deserves, give the analysis, the scrutiny for all the witnesses, all the evidence, and talk amongst yourselves, that you guys will come to the correct verdict. And I would suggest that that verdict is the verdict of guilty on all counts. Thank you very much. Very briefly.
Sure.
So 6 minutes for the state's closing, 22 for the defense. This has been the defense show all the way through. The state had the longest witness with the alleged victim, but she sort of made that long because of her stubbornness and refusal to cooperate in many ways. Oh, yeah, he didn't seem convinced. He didn't seem convinced. He's like, whatever you do, don't go in there and just take a straw poll because we're going to lose. I don't want to have like a 10-minute verdict against me on my record. No, he didn't say that part, but that's what I heard. Commonwealth got embarrassed. If the verdict takes more than an hour, I'm filing a dispute. BAP. Oh, man. Sounds like he does not believe his own client. She's not a perfect witness. She had some credibility issues. Oh, he didn't say that. He said she was difficult. Instructions from the judge now for the jury, including reading the charges, the verdict form.
You are about to begin your final duty, which is to decide the fact issues in this case. Before you do that, I will instruct you on the law. It was obvious to me throughout this trial that you faithfully discharged your duty to listen carefully to all the evidence.
She's moved away from her mic.
I now ask you to give me that same close attention as I instruct you on the law. My function as the judge in this case has been to see that this trial was conducted fairly, orderly, and efficiently. It was also my responsibility to rule on what you may consider as evidence and to instruct you on the law which applies in this case. It is your duty as jurors to accept the law as I stated to you. You should consider all my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. It was the duty of the attorneys in this case to object when the other side offered evidence which that lawyer believed was not admissible under our rules of evidence. They also had an obligation to ask to speak with me at the judge's bench at sidebar about questions of law which the law requires me to rule on out of your hearing. The purpose of such objections and rulings is not to keep relevant information from you, just the opposite. It's to make sure that what you hear is relevant to this case and that the evidence is presented in a way that gives you a fair opportunity to evaluate its worth. You should not draw any inference, favorable or unfavorable, to any attorney for objecting to proposed evidence or asking me to make such rulings. That is the function and the responsibility of the attorneys here. Now, your function as the jury is to determine the facts of this case. You alone determine what evidence you believe, how important any evidence is that you do believe, and what conclusions to draw from that evidence. In making these determinations, you are to use your common sense, life experience, and good judgment. You are to decide what the facts are solely from the evidence admitted in this case. In evaluating the evidence and determining the facts, keep in mind that we all tend to perceive information and form opinions based on our own personal experience and background. This tendency may cause us to hold bias, of which we may or may not be conscious. And as I previously instructed you, you must not allow bias, whether held consciously or subconsciously, to interfere with your ability to fairly evaluate the evidence, apply the law as I instruct you, or render a fair and impartial verdict based on the evidence before you.
The poll is up on
The
jury
evidence
deliberation.
consists of the testimony of witnesses as you recall it, any documents or other things that were received into evidence as exhibits may also be considered. Of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses. It's the weight of the evidence that is important. Some things that occurred during a trial are not evidence, and you may not consider them as evidence in deciding the facts of the case. The complaint itself is not evidence. A question put to a witness is never evidence. Only the answers are evidence. Also, you may not consider any answer that I struck from the record and told you to disregard.
So there were about 19 of those.
Do not consider such answers. Anything that you may have seen or heard when the court was not in session is not evidence. The opening statements and the closing arguments of the lawyers are not evidence. They are only intended to assist you in understanding the evidence and the contentions of the parties. If your memory of the testimony differs from the attorney's, you are to follow your own recollection. You should not consider anything I have said or done during the trial as any indication of my opinion as to what your verdicts should be. In evaluating a witness's testimony, you have to decide what testimony to believe and how much weight to give that testimony. You should give the testimony of a witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of a witness. You may believe everything a witness says, part of it, or none of it. If there are any conflicts, discrepancies, or inconsistencies in the testimony, you should examine them carefully. You may consider whether a witness was candid or guarded, responsive or evasive, and whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity a witness had to observe the facts about which the witness testifies and whether the testimony seems accurate. You may also consider evidence, if any, about a witness's motive for testifying, whether a witness displays any bias in testifying, and whether or not a witness has any interest in the outcome of the case. In deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense, life experience, and good judgment. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you have gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. Once you have determined the facts, apply the law as I explain it to you to the facts in order to decide the verdicts. Now, there are two types of evidence which you may use to determine the facts of a case: direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about the fact that is to be proved based on what he claims to have seen or heard or felt with their own senses, and the only question is whether you believe the witness. You have circumstantial evidence where the witness cannot testify directly about the fact that is to be proved, but you are presented with evidence of other facts, and you are then asked to draw reasonable inferences from them about the fact which is to be proved. Let me give you an example. Your daughter might tell you one morning she sees the mail carrier mailbox. That's direct evidence that the mail carrier has been to your mailbox. On the other hand, she might tell you only that she sees mail in the mailbox. That's circumstantial evidence that the mail carrier has been there. No one's seen the mail carrier, but you can reasonably infer that the mail carrier has been there since there is mail in the box. The law allows either type of proof in a criminal trial. There are two things to keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you. The second rule is that any inference or conclusion which you draw must be reasonable and natural based on your common sense and experience of life. If the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty, and that there is no other reasonable explanation of the facts as proven. The evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all the evidence in the case. Now, excuse me. When you consider whether to believe a witness or how much weight to give their testimony, you may consider whether that witness said or wrote something earlier that differs in any significant way from their present testimony in the courtroom. It is for you to say whether there is a difference and how significant any difference is. Please note that you may not use the witness's earlier statement as proof that something said in it is true. So, for example, if a witness testified here that she found a donut but had earlier written that they found a bagel, that earlier statement would not prove they found a bagel, but it might raise doubt as to whether they were accurate or truthful when they testified that they had found a donut. So the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. It's for you to decide whether it does so. Normally, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. The rule rests in part on our common experience that saying something repeatedly doesn't necessarily make it any more or less true. But we make an exception to that rule where there has been a suggestion that a witness may have recently contrived their testimony. In determining how reliable a witness is who has been accused of recently inventing their testimony, you may consider any earlier statements that the witness made which are consistent with their present testimony. It's for you to say how important the consistency is depending on when any earlier statement was made and any other circumstances that you consider significant. The earlier statement is not itself evidence of any fact that is mentioned in it. To repeat, if there has been a suggestion that a witness recently contrived their testimony at trial, when you evaluate that claim, You may also take into account any earlier statement the witness made which is consistent with their present testimony. The prior statement is relevant only as to the witness's credibility, and you may not take it as proof of any fact contained in it. At this trial, you may have noticed that the defendant did not testify. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that he is innocent. The fact that the defendant did not testify has nothing to do with the question of whether he is guilty or not guilty. You are not to draw any adverse inference against the defendant because he did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits.
Verdict form now, Judge.
As I have told you, the complaint against the defendant is only an accusation. It is not evidence. The defendant has denied that he is guilty of the crimes charged in the complaint. The law presumes the defendant to be innocent of the charges against him. The presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since he is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless his guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. Now, as I've said, the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if after you have compared and considered all of the evidence, you have in your mind an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until they are proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. The defendant is charged with having committed an assault and battery upon Mila Adams. In order to prove the defendant guilty of committing an intentional assault and battery, the Commonwealth must prove three things beyond a reasonable doubt. First, that the defendant touched the person of Mila Adams. Second, that the defendant intended to touch Mila Adams. And third, that the touching was either likely to cause bodily harm to Mila Adams or was offensive. To prove the first element, the Commonwealth must prove the defendant touched Mila Adams. A touching is any physical contact, however slight. A touching may be direct, as when a person strikes another, or it may be indirect, as when a person sets in motion some force or instrumentality that strikes another. To prove the second element, the Commonwealth must prove that the defendant intended to touch Mila Adams, in the sense that the defendant consciously and deliberately intended the touching to occur, and that the touching was not merely accidental or negligent. The Commonwealth is not required to prove that the defendant specifically intended to cause injury to Mila Adams. To prove the third element, the Commonwealth must prove that the touching was either likely to cause bodily harm to Mila Adams or was offensive. A touching is offensive when it is without consent. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of the elements beyond a reasonable doubt, you must find the defendant not guilty. The defendant is charged with strangulation. To prove the defendant guilty of this offense, the Commonwealth must prove three things beyond a reasonable doubt. First, that the defendant intentionally applied pressure on the throat or neck of Mila Adams. Second, that the pressure was substantial. And third, that the pressure interfered with the normal breathing or circulation of blood of Mila Adams. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant intentionally applied pressure on the throat or neck of Mila Adams. The Commonwealth must prove that the defendant consciously and deliberately intended the touching to occur, and that it was not merely accidental or negligent. You may examine any evidence regarding the defendant's actions or words and all the surrounding circumstances to determine whether the defendant intended to apply pressure to the throat or neck of Mila Adams. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the pressure was substantial. You may consider evidence, if any, about how, where, when, and for what duration the pressure was applied, as well as any evidence of its effect or impact on Mila Adams. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that the pressure that was applied interfered with the normal breathing or circulation of blood of Mila Adams. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of the elements beyond a reasonable doubt, you must find the defendant not guilty. Counsel, I'll see you at sidebar.
Yay, another sidebar. Didn't get a judgment of acquittal motion that we know of. Might have happened at sidebar. Maybe he wants the jury to find him not guilty. Failed to prove any. She had nothing to corroborate her story. No photos, no stories, no phone calls, no text messages. Let's see here. Still beeping. Is 2 done? 2 is done. Okay. Beep, 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 beep. This poor guy in the blue suit only gets to talk to Mr. Diggs when the other lawyers are gone. Here we go, we're back. Nope, we're not back. Just messing with the audio settings. I missed all but first witness for defense. Oh, drama llama mama. You need to watch the first witness for the prosecution.
All right, jurors, when we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise during the course of the trial which will require one of our jurors to be excused from further jury duty. So, in order to avoid having to start the trial over again, should that occur, we impanel 7 jurors, even though the case will only be decided by 6 of them. So the time has now come to reduce your number to that 6, and I am going to ask Mr. Clerk to draw one of your cards at random, and
one
that
of you
juror
is
will
going
be
home.
Designated as our alternate juror and will not take part in the deliberations unless necessary to provide a substitute for one of the other jurors. So if fate makes you the alternate juror, please don't take it personally. Your service up until this point, your willingness to serve is appreciated by all of the parties, and we will make sure that you are kept as comfortable as possible in an area isolated from the deliberating jurors.
Just know that you also don't get to ride in the Maybach alternate
That
juror.
would be juror number 1 in seat number 1.
All right.
Juror 1,
Stay
seat
right
1.
there. You will serve as our alternate, but as I say, we'll make sure you're kept comfortably in a different location.
Like,
if you would be good enough,
what?
Mr. Clerk, to draw a number card, another card at random, this particular juror will be the foreperson of this juror.
Oh, random. I don't like this. I don't like it.
That is juror number 25 in seat 4.
All right, so you will be the foreperson of our jury. All right? What that means, oh, Mr. Clerk, thank you, is you gave it to me right here. The juror has who is designated as the foreperson has the responsibility of recording the jury's verdict on the verdict slip. Once that has been recorded, you sign it, date it, and inform the court officer that the jury has reached a verdict, and you will be brought back into court. Now, if during your deliberations the jury has any question, the foreperson should write out the question on a piece of paper, sign it, date it, fold it up, let the court officer know. They will bring the question to me, and we'll proceed accordingly at that time. Now, you're not to make any use of cell phones or any other kind of personal wireless device during your deliberations. Incoming, outgoing calls, or any other kind of electronic communications can disrupt the deliberative process, or even allow for the receipt of improper extraneous information. So you're not to conduct any outside research or investigation by means of the internet or otherwise about the law or facts of this case. If during your deliberations there is a request to view any of the evidence that is not physically with you, for instance, there are flash drives that contain certain of the videos that were displayed here in the courtroom. If the jury should like to see any of that, if that is just requested in any note form, we will bring you back in here and make sure that that is displayed for you as many times as you might like. All right, so just let the court know by mentioning that in a note. At this point, I am going to ask Mr. Clerk to swear the court officers in, and they will escort you to your deliberations.
Do you swear that you will keep this jury in some convenient place until they are agreed, that you will not suffer any person to speak to them, nor will you speak to them yourself, except by order of the court or to ask if they are agreed, and that you will not permit them to depart until they have agreed upon a verdict, except by order of the court, so help you God?
I do.
Here's the verdict slip. And can I have that sheet of paper? Thank you.
All rise. Jurors can step down this way.
All right, we are going to start the timer as soon as the door shuts.
May be seated.
Counsel, I'll see you over here.
Timer's going. You get it on screen if you'll give me just a minute. Let's see.
Yeah, just a little housekeeping. So here we have the list of
We're not at sidebar. We're just. I guess this is more sidebar than any other sidebar we've had. Super source. Box 4 is
Kill feed. Is it feed out?
Camera 7.
310.
One, nope. Box 2, yep. Box 2 is camera 3. Cut. There we go. Give me a second to get this on the screen right, though. All right, we might need the milliseconds on this one. We're a minute in already. My goal is to have the timer set up on the screen before the jury comes back with the verdict. I know that's it's a high bar, but I think I can do it. Let's see. Let's get this a little bit bigger. Right about there. We'll move up a tiny bit. Right about here. Right about now. And we'll crop this down just a little bit to leave some room. Well, it looks like they're going to take care of that for us. Feeds down until we come back. Left. There we go. Okay. So now we get to wait. Let's put us in there instead. Box 4 is going to be camera 4. There we go. Now we have a little timer going in the corner. The poll's going, so we're going to go ahead and stop that in just a second. Get your votes in right now. Right this very second. Because I am going to end it here in just a second. We've only had, let's see. Oh, I can't tell. We had a little over 420 votes. Should we stop it at 420? No, it's too late. It's 422, 423, 424. A couple of you still voting. Get in right now. And 425. Poll says, how long will the jury deliberate? Your options are less than 30 minutes, 30 minutes to an hour, 1 hour to 2 hours, or can we get hot dogs for dinner? Option number 4, the least popular at this time. Okay, we're almost up to 340, 342. Sorry, 442, 445, 447, 440. Can we get to 450? 450, which will be over half the group here right now. We'll go ahead and end this one. Boom, done. All right, the poll comes in under 30 minutes to 1 hour is 49% of you. Less than 30 minutes is a 33%, and the 1 hour to 2 hours is a 15% with, can we get hot dogs for dinner? Just 3%. 3% of you would like to have hot dogs for dinner. I'm not a fan myself of at least the hot dogs that are offered in this trial, which did not sound gourmet in the slightest. Let's take a peek here as we watch the clock. All right. Whew. Poll's back. Poll's back. Well, the clock's back. The poll's done.
Hello.
Got a couple things we can do while we wait. We could, of course, we could go watch somebody like, I don't know, standing judge, who is, where's he at? He's at 6, right?
The court date will be at the circuit court level. You understand all that?
Yes.
And understanding all of that, are you waiving your exam freely and voluntarily today?
Yes.
Mr. Cripps, are you satisfied?
I am, Judge.
All right. AOI date's 2 weeks from today. Well, look at that, Heather. Would you believe that? We are how many days into May?
5.
Holy cow.
5.
I'm having so much trouble because the calendar has not been updated by our court officer.
Oh.
But his hair looks really nice today.
Somebody's in trouble.
It's been noted on YouTube, by the way. Yeah. So, Mr. Cripps, we're looking at an AOI date on can't see through your arm. That would be the 19th?
Thank you, Judge.
All right. Bond will be continued unless you say something quick.
I have nothing further to add. Thank you.
Good luck downtown, gentlemen.
Thank you. Thank you.
You're welcome, sir.
All right.
What do we got ready? We got a lot of files up here. Which we're waiting on.
Let me bring the.
She is out there.
Okay, because we need to do her client so we can do the arraignment.
So
We need attorneys is what we need.
yeah, I do. So the show cause, if they're here for a show cause, set up like, right? Or are you reading him in show cause?
No, they just send them to the prosecutor.
That's what I thought. Okay, he's. That's what happens.
Thank you. They're not ready yet, are they? Or Sharon's our arraignment attorney?
Give me a second. I'm going to bring in the other view as well.
Yeah.
She said Greer's our arraigning attorney.
Mr. Green is covering for.
Oh, okay. Mr. Green, you have not yet talked to your defendant?
I have not.
Okay. All right, we need to get you in with the jail.
No, that's
Okay.
They're loosely.
Oh, right there. Oh, okay, got it. All right, but we're waiting for the attorney on Hooshley.
He said he got it. Well, pull him and break up with me.
Who's the attorney for Derek Hooshley?
It's Vanessa right there.
Ah, are you ready? Derek, go ahead and unmute.
Messed you up. I messed you up.
Pronounce your last name for me.
Sorry, Your Honor, it's a hard one. Everyone has a problem with it. It's Houchley, like couch.
Houchley.
Yes, sir.
Easy as pie once I know how to say it.
I've heard
Counsel, your appearance for Mr. Houchley.
Vanessa Hamilton, PH21
All right. So we need an exam date? Is that what we're doing?
Yeah, we're just gonna
Okay.
vote for.
Houchley is already scheduled for May 12th at 10:30. Get good?
That works perfect.
And just leave it as is?
Yeah, we'll keep the date as it is, Your Honor, and I'd like to respond.
All right, we're probably going to need a prosecutor then. Joe?
Yeah.
Who have you been talking to, Mohammed or Kaplan?
I talked to both, actually.
Well, then whoever we can get in here.
Just get somebody.
Good?
Yeah.
Yeah. So we're confirming 10:30 on the 12th works. Mr. Mohammed, counsel is going to make a bond argument on Houchley. And currently it's 25,000, 10%, GPS tether, no alcohol or controlled substances, correct?
Correct.
Sounds correct.
Make your argument.
Your Honor, I would just ask, if possible to have this moved either to a personal bond with GPS tether to Mr. Houchley's brother's house. He can provide that information to a tether agent. Or, Your Honor, an alternative probably to consider just a personal. We would ask for a bond to for the language to be changed to allow him to be admitted to an inpatient treatment center for either mental health or substance use treatment.
Okay. I'm a big fan of treatment. I mean, you got a bed anywhere?
So I don't have a bed anywhere. My understanding is they have to go through the jail through D-Wing to be placed.
All right. Mr. Mohammed, on behalf of the people, any objections if we just put a notation in the file that we're all right with a conversion to a personal bond if he has a bed?
Yes. Was it going to be with a GPS tether?
He's currently on a GPS tether, so the only change council's asking for is the cash bond would be changed to a personal, correct?
That's correct.
So currently he's on a GPS tether, no alcohol or controlled substance, and the bond is 25,010. She's just asking for a personal bond. Everything else is the same. Personal bond if he's in treatment. Yes?
That's correct.
Any objection?
The defendant will be tethered to that treatment facility. We have no objection.
Okay. All right. So why don't we just leave the bond as is with the understanding if you find that he got a bed, you contact us and then we'll change the bond.
Okay.
Does that make sense? All right. So currently we got Mr. Houchley, you got this. Your exam is May 12, 10:30 in the morning right now. If you get into a treatment center, counsel contacts us. We'll change to a personal bond so you can get in that treatment center, and then I'll adjourn the exam as long as you're in treatment.
Yes, sir.
If we'd like to hold the exam,
Well, that's up to you, but I'm just saying, yeah. Yeah, I'm just saying if he's in treatment, I'll work with him on the timing.
Okay.
All right? Good luck, sir.
Yes, sir. Thank you.
Counsel, you know how to find us.
Here, get the The deputy.
Are we ready on Prater?
Wait, I'm attorney.
Okay. Deputy, we need Jeremy Anderson up next, please.
Okay, got you. So you good.
And it's a need.
Thank you.
You're welcome.
Did we lose Mr. Green? No, he's down the phone. Mr. Green hasn't spoken to his client yet, has he? Okay.
Like this judge. I'm just saying. While the jury's
Mr. Green, as soon as we get Anderson in
deliberating,
that chair, we'll put you both in a breakout.
11 minutes.
All right. Thank you, Your Honor.
You're welcome.
Who's the holdouts?
I got a lot of bodies, no attorneys. Go find your attorney, get him in here, we'll get you out of here.
Go find your attorney. Does anybody get up? None of them move.
You have seen they wait for you. When you're done here, you're done after the judge came there and instructions and stuff. Okay.
Good morning, Mr. Anderson. We're going to put you in a breakout room so you can talk to your attorney. Understood?
Understood.
Man, we've only got a couple minutes to come in with the record shortest verdict ever. About 2 minutes. I'm a sucker for a Fenway Frank. Okay, I like a good hot dog as much as the next guy. I do prefer beef hot dogs. And over that, I prefer brats. And you've got to use mustard. But the way they described it in this case, just being like a shriveled, dried up hot dog with a little bit of mustard on it, that's not gourmet. That's no good. No, you need relish, like lots of relish, and maybe some ketchup too. I'm a fan of ketchup. And the hot dog has to be at least as big as the bun. At least. You can do equal size or bigger, but you can't do smaller hot dog than the bun. That's not the same. This trial just feels off. Plaintiff not believable and did not help her case showing her personality.
Hey, Joe, be helpful if they put their name up here so I knew who I was dealing with. The attorneys. None of them are.
Nathan's for you.
This is my first time.
No, the attorney should know better. So you just got to train the attorney.
Yeah,
they're doing the paperwork. They haven't put the name. Yeah.
You, sir, should know better about the calendar, but the attorneys need to put their names on their paperwork.
Is Tyler in here? How do you pronounce the last name? Say it again. Man, you got a lot of letters you're not using. One more time. One more time. Kurjev. Who's your attorney? Cohen? What did we just give him for a date?
You've got a lot of letters you're not using.
Yeah. Oh, and it's June 9th on the road days.
Are you available June 9th for your exam? We'll confirm that with your attorney, but he's already got one that day, so what time would you do this one?
Do it at 9. Right now, he's scheduled for next week, so it just depends on if he wants to.
Okay. Okay, I don't understand what Steve did with these plea agreements. So I've got a guy here, he's got a civil infraction registration or plate, misdemeanor operating while intoxicated, and misdemeanor no insurance.
Check on it.
If this doesn't, he wants me to dismiss counts 1, 2, and 3. And take a plea to no proof of insurance. Oh, he's changed them to civil infractions. It's going away.
I double checked that to be sure.
Good morning, Mr. Kaplan. Or no, what's your name? Hadley. I always get the Josh's, which is hilarious because he's got a lot more hair than you do.
He does. Well,
He's looking very distinguished. Have you seen him lately?
yes.
Getting a little white in his beard.
But Cap,
Yeah.
he's doing some kind of like bodybuilding.
Is he really?
Something or other. Like
Thought they were
he's
talking about beef.
dropped and like gotten into.
Good for him. Well, I can't tell that on Zoom.
Yeah, he's much more distinguished. He gets someone he got like ridiculously shredded.
Good for him.
Like, hey,
The guy's ripped.
I mean, comes three things. She's one. You would say he's.
Not so far.
I was just reading the ROA. It seems like we got history of him being in the residential.
Oh, I think he, now that you're saying that, I do remember.
But this is the case. Slow stomach. He had a Van Buren case that was dismissed or adjudicated. On Patterson, not yet. It's my conflict. On Williams, it's Jake Jacob, but I'm trying to run him down right now.
Okay. Well, because I'm just wondering because I mean, yeah, what's the, if the.
Oh, good point.
Do we know who the attorney is for Prater?
MIDC. Grenada.
Okay, we're over 16 minutes. We have not broken the record. We're waiting on the football trial. That's in the corner. We've got the timer going. They've been deliberating for 17 minutes now.
What did it say? Like,
He has good hair, but he's only 5 days late from June to kill. Mr. Cohen, you ready?
Hi. Yes, on your check, but also if I can approach, I have a exam form for more. You have from me?
No, not yet.
Okay.
All right, counsel, your appearance on People versus Taylor Khrushchev.
Service by go on DA65 hearing on behalf of the security check. Come on, who's that custody?
You all right with the June 9 exam date?
That is good.
All right, let's do June 9 a.m. Bond will be continued.
Sounds good.
All right, you have a seat. Go back with your folks or whoever that is. We'll get you a notice, paper notice. We'll get you out of here.
This client didn't even get to take a seat in front of the bar. That was quick. Who else you got?
Oh, so much yellow.
Judge Oakley is great. He does stand. He's got a little bit of an attitude, and those people were all there to talk to that guy. They're all there to support.
Heather?
Judge.
I've got a file that says we got a trial scheduled.
Ira Jones?
No, Clayton Spence at 11.
Clayton Spence is the attorney.
That's
the defendant.
That's why I can't find the file.
Got a trial scheduled? Judge.
Good job. 1 second. That's right.
He's the attorney for Aisha Moore.
It's Mr. Coleman. Relation with and DOC. We present to jump on probably closer to 10.
He's got a bunch of misdemeanors too.
Got a little movement in court, but someone could be tripping over the cord.
So she's currently scheduled for an exam on the 12th, so we're going to see if she wants to move that up to the 9th.
Oh, yeah. With it being MDOC, with being available to sender and everything, so that they would be better.
So I've got a Romulus GWLS, we're going to need a date on that.
Laura Frey, we're not following the FedEx trail.
Oh, there's paperwork in here somewhere? Oh, that's what that is on the front. Okay.
And the other ones, she just owes money.
Okay.
Yeah, they turned me on a bunch of stuff.
Okay. I don't see an email. Ah.
He's on top of me.
Oh, yeah.
Council, are you ready on Prater?
You're all right.
Your appearance.
We're going to 278-413, and my council approves the prayer.
Good morning. All right, so the plea agreement I've got is that Mr. Prater is going to plead to 3 civil infractions. No proof of registration, no proof of insurance, and impeding traffic. If I accept that plea, Mr. Kaplan's asking me to dismiss both the misdemeanor charges that were issued on April 11, 2026.
Yes.
Right? So the only thing I'm not going to do on this is I'm not going to take a plea to impeding traffic because that just causes extra work. I'll dismiss the 2 misdemeanors. I'll take his plea to the no proof of insurance civil infraction and the no proof of registration civil infraction, and I'll just hit him a little harder on the money on those to make up for the impeding traffic. To you, it's just same to your pocketbook, less work for her. All right. All right. So that's what you want to do. You want to plead responsible for those civil infractions today?
Yes.
All right. So the no insurance or no proof of insurance civil infraction is 180.
What's that?
The fines and costs on the insurance civil infraction is 180 and registration is 150. Can you pay those today, or you want a due date? You need a payment plan? You need all your options? Pay them today. Take care of it today and get out of here. Have a great day.
10.
So downstairs?
Yep. Go downstairs. The cashier will smile when she takes your money.
Yes, she will.
You're welcome so much.
They will take your money. And they will smile. And they'll be like, cha-ching.
Who's next?
Mr. Gill.
Gil?
You know what, you're all right. I'm going to talk to the state prosecutor on this one.
Okay, then you're not ready for me. How about Daquan Woods? Is that yours?
Woods, are you? Yes, come on.
Come on up.
Thanks for dressing appropriately for court.
Your appearance.
Good morning, Eric Peter, 278-413, MIDC Council for Mr. Williams.
All right, so same deal. He's going to plead to a civil infraction, no proof of insurance, right? All right. I'll accept your plea to the civil infraction, dismiss the misdemeanor. Fines a cost 180. Can you pay it today?
180 is the go-to number.
Oh, let's see what's today. Can you pay it by the 15th, or is that not enough time? Good.
Little Stubby, happy wedding
You're all set.
anniversary to you and your spouse. 36 years. That's awesome. Thanks for sharing that. And you shared a little sunshine as well, if I can make it appear on the screen. Which there we go. Little sunshine. Thank you.
Yeah.
Why am I still thinking about
So you
hot
can
dog
catch him.
water?
He owes us money on some other stuff. Woods.
That's so, Jessica. That's because you can smell it. The words sound just like they smell.
And gentlemen, we're also ready on Gil, whatever it's. I don't know right up if you'd like, but we're setting for
I'm sorry, you're doing what?
setting for final neutrality.
Mr. Wood, you owe us money on some other stuff. You can pay the 240 today. 2 weeks, you can pay the 180. You're good. You're good. I just want to make sure you knew about it. Mr. Gill, come on up.
Pay up.
Counsel, your appearance.
Morning, Eric Peter, 78413, MIDC Council for Mr. Gill.
And you want a final pretrial with complainant to appear?
Yes.
And pick a Tuesday.
A hot dog is a taco. Oh, them are fighting words. Them are fighting words. Karate Kid, Mom.
You don't care, do you?
I'm gonna try to pick a day that I'm back, but, or any day I'm free.
Just go ahead. Just pick a date.
We're having nachos tonight. I know it's Taco Tuesday, but we're doing nachos, which is, it's basically like a lot of little tacos, right? And yes, I did get married on Cinco de Mayo. That's awesome.
June 2nd?
Is that a Tuesday?
Guess the wedding dinner was an easy plan.
Who's that with, Heather, and what time you want to do it?
June 2nd, Judge Patton, 9:30.
All right, so gentlemen, are we agreed that the complainant is going to be on Zoom that day? All right, that's a Zoom hearing. All right, bond will be continued.
The STF's hearings officer
We'll get you a paper notice for that date.
is miles away.
Counsel, what else you got?
Sarah Sherwood, member for 27 months. Wish I could have tacos tonight, but my husband's recovering from a bad reaction to morel mushrooms. Were they false morels?
I'm looking for a file.
That's dangerous. The trick is the
Did Singleton already go your way?
The bottom of the mushroom cap has to be connected.
It should be up there.
Oh, they were real?
I've seen it. Oh, here you go.
This is taking about 14 minutes longer than I thought it would.
Okay, Mr. Singleton, you understand the rights and options you have today?
I can barely hear you, Bob.
Do you understand your rights and options?
You can barely hear the judge?
Okay. Do you understand the possible penalty for the added charge? Are you pleading guilty to that charge freely and voluntarily today? Did you drive a vehicle in Belleville on April 7? Did you drive a vehicle in Belleville on April 7th? Was your license suspended, revoked, or denied at the time? I'll accept your guilty plea to the added charge, dismiss the original charge. What's the status of your license now? All right. Are you working? All right. When's the last time you had a job with a schedule and tax withholdings and the whole 9 yards?
Clocking in Bell, probably 2 years, 3 years at the most.
All right. Anything you want me to consider before I set the terms of sentence?
You can recommend some help to help me get my license back. That would be cool.
I don't know what's wrong with your license, so I can't. What's wrong with your license? What's the problem?
I guess tickets added up with the driver and too much.
I think
you owe too much money. You can't pay it.
Yeah, that's not a license problem.
Which jurisdictions that have holds on him, but I don't see any bonds. I don't have any warrants.
Right. I don't know of any warrants. That doesn't mean there aren't any. I just don't know of any. So probably the best thing to do is go to the Secretary of State, ask them which courts you have to go to get cleared up. All right. Anything else? All right. Go ahead.
Plate also that day, but and it wasn't my vehicle, my fiance's vehicle. So will she be giving that back?
She's got to come up here and file a 1-page document. It's called an innocent owner. That you can do that down at the counter. It's the innocent owner release. All right. Anything else? Okay. So I'm assuming you have more time than money right now?
You have more time than you have money.
Yeah.
Because usually on these files, I get $500 fines in costs and 4 days on the work program. If you'd rather schedule more days on the work program, I'll give you a break on the money.
Well, but I have to come out here.
Unfortunately, it's here.
You gotta pay.
Oh, you're in Oak Park.
Tim Schaff, best place to watch. Thank you.
Let's do something different with you.
Months. OG. Congratulations on that red courthouse. That's awesome. It wouldn't be the same without you here. Thank you so much. About to lose on the jury time. Got 30 minutes in.
How about $200 money and 50 hours charity work?
Whoa. Oh, 50.
$200 cash and 50 hours of charity work. You can do that in Oak Park, wherever you can find it. Church, soup kitchen, Salvation Army, any nonprofit that's registered with the IRS. You volunteer with them, get 50 hours documented on their official letterhead, send that to us. That'll take care of that end. And then $200, I'll give you a due date or a payment plan, either one. What do you want? Due date or a payment plan? Set that up downstairs. How long to do 50 hours? Can you do that by the end of June? That gives you basically 2 months. Any questions? Good luck with your license. Oh, you owe us money on some other files too. Can you set something up on that one? We got a Drovo license suspended, shows you owe $240 from, hold on, is that this one? Why are they showing that he owes money on a file he's never even been in? You know. Oh no, the registration. You got a 2023 registration or plate charge you owe money on. Can you set that one up? Yep. Yep. Can you set something up on that too? Some kind of payment plan. Can you set something up? All right, so go downstairs, set up a payment plan for the total of $430. $440, excuse me. Got it? And you're going to do the paperwork.
Your Honor, we have no other.
How was that possible?
Things been in jail, picked up, and they took 5 to
All right, did we lose Mr. Gill? Mr. Gill, come on up. Somehow he's never been arraigned. I saw the bond in the file. So would you waive formal reading? I'll enter a not guilty plea for you. Understood? You're welcome. Now you can go sit down. I guess I could have yelled at you and done that from there.
Your Honor, I have only one other signature on the sign sheet, so I'm going to go interview that.
Awesome. Counsel, who do you got?
I have nothing except to ask for some follow-up.
That means it sounds like he needs to beg Heather for something.
No, it's he needs to talk to you because he's trying.
Just a moment, Judge.
Yeah.
It's another one of those.
It's another one of those Bucky. Thank you. Yeah.
Judge comes off the bench.
Did you get requirements?
He went through the website. I don't. There's other ways.
What's in your? She wrote some desert old leases. No idea about it. Yes, she has. She's been all over the chance. North Africa. James South Africa.
Oh, no, that's not yours. No.
Serious. Yeah.
Yeah, wait.
That's what she told us. I'm over there. See, I know you got me. I don't know. I'm talking to I don't know what it is. Not talking. I know.
So we're gonna mute that. It's over 33 minutes. If the jury room is as warm as my studio right now, they're probably all asleep. They forgot to knock on the door saying they were done already. Now they're just taking a nap. But maybe the jury's having hot dogs for a snack, holding out for free dinner.
It's cool.
The Zoom ID, I can give it to you. Otherwise, you can go on our website that day.
This one in the mail.
No, I'm trying to hand you what would come in the mail. No, let me give you what comes in the mail usually.
$700. She went on maternity leave, she got paid, and she said it went in the fall. So I filed a motion to set aside, and some judge, one of you guys, I made a better reason. My secretary, I was out of town, you sent it, and whatever they owe, whatever, just let Caitlin figure out what we owe. I never find the tickets. But the clerk here said it's too late to make a deal. I'm just going to start making.
Alex Green's landing planes there with that headset. I like it.
Well,
I think he's in a cubicle, but he's got his own mini split cooler right
Have a great day.
He's got his own private AC for his quarter.
I'm not going to. You guys just set a new date and we'll pay it. Caitlin will send you.
You got paperwork on this thing today? Housing?
No, probably.
He
I just called her. I said, how do I? And you know, I haven't been here in over a month and they were looking for me. They had my picture on the board with a donut over my face. So Judge, stay here at the American Embassy in Rome.
A donut?
Great. And Mr. Gagniak will be right back.
Do you know that with
I speak French. I don't speak Italian, but we had one Slovak meeting where they spoke French, Italian, English, and Slovak, and I could understand. And after you're there a few days, French and Italian sounded like I love the people in Italy, and my kids are half Italian, so
I like the food.
He just
needs a date for a formal hearing.
Formal. I'm going to plead it out. Judge, it was
No problem. No problem.
Came out to say.
Always a pleasure. Hey, who's on straight? You ready?
I'm getting out of here.
Brian Straight.
Is Straight on Zoom, counsel?
Yeah.
We go up here next door.
Oh, there we go.
I listen.
All right. Mr. Straight, you there?
Yes, Your Honor.
All right, go ahead.
I'm Brian Gang, serving for 50 Service P64220. And Mr. Straight practice, or at least watch me practice while he's online.
All right. And you need an exam date?
We accept the 12th. That's
It is. Heather, what time are we going to do that?
Donut face. Yeah.
He's got a bunch of misdemeanor stuff, too.
A bunch? Like, how many's a
Date
bunch?
for his next day,
Oh, okay.
if you want to do that.
So I'll continue bond on this felony file. May 12th, who's that with? Is that with Pat?
May 12th is with us.
That's me?
Yeah.
All right.
Date.
Okay. All right, so let's see what we got for files. Let's see, I've got a June 2020, drove while license suspended from Romulus.
Ooh, that's bad.
Would you waive formal reading on that one? We'll get him a date on that in just a minute.
Okay. Brian doesn't like that one. He shook his head. I don't know what donut face is.
All right, then we've got another one from Romulus from that same date, failed to stop or identify. Waive formal reading.
That's also bad.
Heather, we need a Romulus date.
It's in there. I think it says May 8th, 9 a.m. Judge Oakley. It's written on one of the pieces of paper and the inside.
I don't know where it's at. What is it?
But that's a person in date.
Mr. Straight, I got an address for you on Rawsonville Road. Is that not a good address?
No, Your Honor, it is not.
Where are you at now?
I'm
at 123 Sesame Street.
We got it already? Yeah. Okay. All right. What was the date? May 8th?
May 8th, 9 a.m.
All right. So you can be here May 8th at 9 a.m., right, on these Romulus cases?
You said May 8th?
May 8th, 9 a.m.
Absolutely. I want to get all this stuff taken care of.
Yeah, that would be good because it's starting to build up.
That's a good goal.
Alex Green.
Yeah, things have been going so good. I'm just like, I've had this stuff following me around and want to get it taken care of.
Yeah, you know, we can only use young and dumb for an excuse for a certain period of time, and after that, we just got to clean stuff up.
I couldn't agree more.
All right. So
he's run out of the young and dumb excuse.
Then I've got a February 2017. That's a money situation. All right. Mr. Straight, I got a February 2017 Van Buren Township ticket that shows you owe us $983.60. Then we got from that June 2020 date, we got a civil infraction, failed to stop, assured clear distance ahead, $448. Are you working?
I am working. Yes, sir. Yes, Your Honor.
Where do you work?
I'm a maintenance manager at a company out here in Moreau called Spirotech. Eventually, I moved out here.
All right, so here's what I'm going to do. I'm going to set these two files, the money files, I'm going to set those up for a review date on May 8th.
Okay.
So when you come in on those Romulus files on May 8th, make sure you don't walk out of here until you do something on these two old files. Have some kind of payment plan, build some kind of payment plan. If you
okay, now question, do I just need to go to the cashier for that?
Yeah.
Okay.
All right. So if you can come in with some kind of cash to make a payment, that would be helpful.
Oh, I will, most definitely.
All right, so I'm just making a note on each of those files, review on May 8th.
I think Alex
now,
Green
the two files I put you on a
playing
court
Call
date,
of Duty right now.
Pre-trial on May 8th, I'm going to put you on a personal bond on those two. Bond conditions are pretty simple. Stay out of trouble and show up for court. You can do that?
Absolutely. Thank you. Thank you, Your Honor. Yes, sir.
All right, so on each of you're welcome. On each of those files, I'm going to put you on a $1,000 personal bond. So raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 on each of those two misdemeanor files if you screw up on bond?
Yes, Your Honor.
All right, so that means in essence, if you don't show up that day, we're going to issue a bench warrant for your arrest, and it's going to cost you $2,000 to get out. Understand?
Ouch.
Yes, sir.
All right. I think we handled everything. All right. Have a great day, sir.
Let me go check this one, but thank you.
All right. And Mr. Green, are you ready on the arraignment?
I am, Your Honor.
Thank you, Your Honor.
Mr. Anderson, you can hear me okay?
Yes, I can hear you.
All right.
And we can
So
hear
I've
you,
got a
random
file
citizen.
here from July 2025. Assault and battery. Looks like we had him scheduled for pretrials and he missed a court date or two and we got off track. So we need to get him back on track with a pretrial. How about June 25 at 9:50? That'll be by Zoom with Judge Patton.
Okay.
All right. Counsel, let's talk bond. Is he in custody on this file or something else?
No, he's in custody on, well, I think something else. At least it started with something else. A couple of charges out of Detroit. He's been in since for about 5 days, but I'm not sure if he had a hold on this file as well.
Okay.
I don't have that
I'm just going to
information.
put him on a personal on this one then.
Okay, that's fine. He's got personal on the other ones too, so I'm assuming that if he and he's on a GPS tether, or it's supposed to be on a GPS tether. Yeah. Okay.
Okay. All right, Mr. Anderson, I'm going to put you on a personal bond on this file. 2 conditions. Number 1, stay out of trouble. Number 2, show up for court on Zoom 9:50 in the morning on June 25. You got that?
Yes, sir.
All right, so June 25 is a Thursday morning. Any questions?
No, thank you. I appreciate you.
You're welcome. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond?
Yes.
Any questions for Mr. Green before I terminate the meeting?
No, probably in a break room. If we can do the breakout.
You want to have another breakout with him?
Yeah, with him. Yeah.
Okay.
We can do that.
All right, thank you.
Your Honor, before I go, what was the court date he missed? He doesn't, for some reason, have it, and I don't have it here. Do you know?
You need the jail after this? Yeah, I can tell you that in just a minute, Mr. Green.
Okay, thank you.
Well, he's missed more than one. I guess the first court date he missed was back on August 7, 2025. Then he missed another one in October of 25. It looks like that might be it.
Okay.
Okay?
All right, thank you.
All right, and when you're done with the breakout room, Mr. Anderson, you can tell the deputies we're done with the video today.
All right.
All right, thank you.
All right, thank you. I don't think I know how to go to that breakout room.
We're going to put you in a breakout room.
Oh, all right.
We'll just move you over.
So, Mr. Woodard emailed and said that his client, Mr. Bruce, at 9:45, of course, they adjourned it to this week for him to retain counsel. No counsel has come through. And Mr. Woodard only stayed on it because though he is, he's downtown. He said that if I let him jump on Zoom, he will jump on Zoom and handle this because Mr. Bruce is doing.
He is here? Yeah, that's fine. Yeah,
Sam, but I mean,
that's fine.
that's the other thing. Attorney.
Yeah, he probably had good intentions to find out what they wanted for money.
There.
Who are we calling?
I think she's here.
All right, we had Cripps earlier. Now we got a client for Cripps.
Yeah.
Okay.
He's probably.
Okay. So I'm going to tell the guys to find Bruce and send him in.
Judge, I'm sorry to interrupt. I'm here for Mr. Cripps.
Thank you. Hey, Mike, find Roderick Bruce and send him in the courtroom.
45 minutes. I'm stunned. I really am.
We lost her.
No, she's muted. She's obviously in another court.
Can you imagine if this is a split verdict? What is it? You got 6 deliberating, right? If one of them is like guilty.
Zoom, or I just told him to jump on Zoom if he wanted to.
I've seen that.
I just talked to him on the phone. He said he'd be here in 30 minutes, but maybe you Zoom. I don't know. That's on me.
Mr. Bruce, just have a seat. We got Mr. Woodyard getting ready to come in on Zoom. We think.
We hope.
Zelnick just out there working. Bro.
I'm trying to keep an eye on
Zelnick
Twitter
just
for you
out there
guys as
working the
well
crowd.
to see if there's any updates.
Yeah, this is a big statement. Bad people.
So glad in closing that the defense raised that issue about the impossibility of slapping someone with an open hand on the right side of their face with your right hand as you stand in front of them, facing them. Kayla Newell, 32 months. What is this life? Kayla Newell, thank you very much. OG. Love it, love it. You're having trouble filling out the form. It is Massachusetts. Anything can happen there. The
You got the
form is
arraignment
probably
form? Oh, it's over here. Over here.
Yeah.
Objection, Your Honor. Member for 13 months says, love it here. Thank you. We love that you're here as well.
So
appreciate it. Congratulations on the year mark.
I'm
Plus one.
saying up here this is YouTube.
Daryl.
Yeah.
Sounds like they're
Denisha says, hey, I'm from Massachusetts.
They were questioning about
So
the
you know.
standing again.
That's what
so
I'm saying.
arrow down
Arrow down.
and just we'll bring it and then hit that.
YouTube?
Yeah.
Bev's notorious form is in use. We're
And
going to
then
have a
it'll be all
mistrial
over
before you know
here.
it.
But earlier they were
Kind of
talking.
split screens.
Yeah, they were talking, and then once we need to go back on Zoom, just hit the down button.
They're all
But
slapping
they were
each
talking
other.
Down button.
Let me show you how it works.
So reduce. What do you? I don't know. Yeah, minimize.
But they were talking about you standing, wondering why you stand.
This is a hill. Is Heather the same clerk from McNally and Oakley?
She's with me. Ryan Straight is back.
Is Judge watching the YouTube comments? Cooper's mom, 36 months, OG. Congratulations to the Red Courthouse. Longer than
Why are you
some
back,
marriages.
Mr. Straight?
Don't come back, sir. I know this is a public courtroom, but we don't want you here. You've already been here.
Oh.
Only 48 minutes into verdict. We're 48 minutes into verdict. Watch. It's crazy. The prosecution had 2 witnesses. They had the complainant and the police officer who took the complaint.
Hey, I don't want to make you feel bad, but I don't think we've ever had anybody on YouTube compliment your hair. They're complimenting Joe's hair today. Probably because there's so much conversation in here about his flow.
He's got the flow. Kelly H. member for 16 months. Kelly, thank you very much.
Thank you, Jamie.
Is that
You know what? I might as well get a seat too.
mom and sisters or daughters? Who's that in the picture with you, Kelly? This profile picture here. I'm trying to look. Welcome. Joe has the flow. They did have lunch provided for them. Remember? But that was before the closings. Mom and daughter. Awesome.
So check out all. Do you want me to just put them in your basket?
Yeah,
You want to just leave them here? I'll get to them as.
You just throw them in your basket when you're done.
That's fine.
Lacey D won't be long enough before I get to new color courthouse.
Counsel, what do you got?
Won't be long before. Yeah.
Hasselbeck.
Pretty quick here. 20 months makes you an OG, Lacey. Congratulations. You are the original GOAT. Greatest of all time.
So do you have one next week already?
Yeah, I got 12 at 9:15.
All right.
Counsel, your appearance on Hasselbeck.
Brian Gag, County Defender.
Closings were 20 minutes
1220.
for defense and 6 minutes
Morning.
for prosecution.
All right, counsel, what do we got?
Sensitive examination dates, there was possibly the 12th, maybe 9:15.
If Heather says yes, it's yes. 9:15 on the 12th,
Why is he back?
and I will continue bond. Ms. Hasselbeck, just have a seat. We'll get you a paper notice.
We're going to be no farther than your hallway.
Okay.
Mr. Straight's back on, he said one of the dates doesn't work. Yeah, go back in, thank you.
Got it.
I'm not sure if it's his Ronald's dates, Judge, or if it's
Yeah.
the 8th is too soon. That's what I wasn't sure. I just wanted to get it done
All
so
right.
that you can get it taken care of
Yeah.
before.
What's our next option?
Is June 18th.
Do we have options?
It's a Thursday. If that's better. 9 o'clock here.
So it's a work issue as well as what I understand.
I just thought I was hearing on the phone. Do you see him?
I don't.
He's on it. Big right there.
Why isn't he on mine?
It's
Oh, because I got to minimize.
yeah, you're still
All right, Mr. Straight, unmute. What
hello,
date did you
Your
have a
Honor.
problem with it? That May 8th date?
Yeah, Your Honor. I
Okay.
didn't realize that was this Friday, and
That's all right.
I had to have some dental work done this week. I don't
It's
know
all
if you
right.
can hear me talking, but
All right.
I've already taken a couple days off. I mean, is there any way I could get another
Yeah.
date?
Yeah, we'll give you June 18th. If you can get in here before then and make arrangements on those one you owe us money on, I would love that.
That would be great.
The court dates for Romulus are June 18th. I'm still going to set the other two up for a review on June 18th in case you don't get in here before then. Understood?
Outstanding. Thank you so much for your help, Your Honor.
No problem. What time we do that? 9?
Yep,
9 a.m. again.
Perfect.
All right.
Thank you so much.
Your written notice will reflect the change.
Okay. Thank you so much for your help.
You're welcome. Good luck with the dentist.
Oh my God. Thank you.
I've been there. That's why I said that.
That's horrible. I'm sure you can hear the way I'm talking.
We won't speak.
Okay.
So the cross is ready, she said she's ready to Turner to set an exam.
Straight back. I thought I had Turner pulled. All right, I'm ready on the People versus Turner.
Morgan LaRusick, member for 20 months. You are also now an OG.
Is Turner alive?
Love
or
you
is
here
that-
every day.
No, he's in the prison. He's
somebody's
in
here.
the MDOC.
Oh, okay.
Sarah Cruz.
Mr.
Kraus.
Turner, that's you up there?
Yes, sir.
All right.
Can you get a little closer to the camera?
Counselor, your appearance for Mr. Turner.
Yes, Sarah Kraus, P81830. I'm standing in for the attorney of record, David Cripps, for Mr. Turner. Mr. Turner, can you state your name for the court, please?
Sarah, are you
Julius
catching the
Jermaine
train right
Turner.
now?
Thank you. Counsel, you need an exam date, or Mr. Cripps needs an exam date?
Yes, and I do believe Mr. Turner needs to be arraigned on the warrant.
All right, would you waive formal reading?
Yes. Stand mute.
All right. We didn't set a date for Mr. Cripps earlier. Yeah, we gave him an exam date this morning, didn't we?
No, that
I believe.
Oh, that was a waiver. That was a waiver. It was a waiver. So pick a Tuesday, Counselor.
Judge, I did confer with Mr. Cripps. He's asking for a date of June 23rd. I believe that should be enough time to get Mr. Turner from the MDOC to the court.
June
That
23rd?
was with us, what, 10 o'clock?
How about 10 o'clock on that day?
That's perfect, Judge.
That's with you.
That's with me. All right, we'll talk about bond in just a minute. So I've got two files. We'll set one for exam, we'll set one for pretrial on that date. Who's got him in custody right now?
MDOC, Judge.
All right. So probably he needs a cash bond on this one so he can start earning credit.
That's correct. I would ask for a low cash bond.
Yeah. I'll do 10,000, 10% on the misdemeanor, or excuse me, on the felony. And on the misdemeanor, I'll just put him on a personal.
Thank you.
Texas
All
Law
right.
Cat, thank you very much.
It's a misdemeanor.
Good
Are
afternoon
you
to you
following
as
all
well.
this, Mr. Turner?
Yes, I'm lost on a misdemeanor.
Yeah, I've got a misdemeanor domestic violence from October 5, 2024 out of Van Buren Township.
Okay.
So we've entered a not guilty plea for you. We're getting you set up for a pretrial on June 23rd, the same date you're going to be here with the felony. Understood?
Yes, sir.
All right, raise your right hand on the misdemeanor. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up?
Yes, sir.
So if you're not here and you're not in custody, that's your that's your fault. It's going to end up with you going to jail and you need cash to get out. Understood?
Yes, sir.
All right. Any questions for your attorney?
No, sir.
All right. Good luck. Thank you, counsel.
Thank you, Judge.
Yeah. Mr. Woodyard, are you ready on Bruce?
Yes.
I got Mr. Bruce approaching my podium now. I understand we need an exam date, counsel?
That is correct, Judge. Just for the court's attention, there are two other defendants in the caption. I don't know whether either of them have been arraigned, but we're ready to set ours.
Well, let's just get yours set and we'll go from there.
Very good.
So pick a Tuesday.
Today is 5.
Next week is too soon for us, but after that, we got openings.
The 19th is good.
Okay. 2 weeks.
And the 26th. Either of those, Judge, whichever is best for your
26th? 26th? All right, we'll do May 26th. What time, Heather?
What time do you got?
Oh, I'm sorry. I forgot you gave those to me. Pretty much wide open in the morning, Mr. Woodyard. 9 o'clock, 9:30?
I'll be there at 9:30. I'll be there at 9:30 a.m. Yes, sir.
The next thing may work, but we do late in the day.
Mornings only. I'm sorry, 9:30 on the 26th?
Yes, sir.
All right, bond will be continued. And that is with Judge Martin.
Okay, very good.
All right, you have a seat. We'll get you a notice. Counsel, what do you got?
Judge, accept my thanks on behalf of your staff. Will you please? They're wonderful.
Thank you. I will, and Heather heard you. I'm sorry, counsel name?
Accept my thanks on behalf of your staff.
Got her. Right here. Come on up, counsel. Need an exam date?
Yes, Your Honor. Not do next week, have a trial. I'm looking.
We can't give you next week. It's too tight already. So pick a date.
The 19th does work for me.
All right. How about 9:45?
9:45.
Yeah.
I can
On the 19th. Exam.
30, so that's it. I mean, I see it. The 19th, let me tell you what we got. Oh, that's because it's me and it's I add that.
So you're all right with 9:45?
Yes, we're
Okay, 9:45, May 19th. Bond will continue. Ms. Gee, is it G or Gee?
G.
Ms. G, just have a seat. We'll get you a paper notice in just a few minutes.
Okay.
Counsel, stick around if you need paper.
Counsel's a
You're
big
welcome.
guy. He's a giant of a man.
Right now.
So fun. These comments are rude. It makes me dizzy when they walk around on Zoom. Yeah, please don't walk around on Zoom. It's like we can't work to do.
No, they're yelling at the guys. Mr. Somebody.
Oh, I got it. Yeah. It's funny. They're chatting back and forth with each other like they're all friends, you know?
Yeah.
Judge has discovered the internet. He's like a kid at Christmas. Okay, here we go. 15 seconds.
So we're done with MDOC, correct? We can get Cal.
Cleared out the courtroom. And we just passed an hour.
Heather, do y'all need new chairs? Is that why he doesn't sit down? All right, YouTube. I don't sit down because I've had back problems since I was in my 20s, and a chiropractor once told me it was healthier to stand. So how long have I done that? Over a decade.
Oh, yeah.
15 years? So probably for 15 years plus, I don't sit down on the bench or in my office.
Love him answering questions from YouTube.
I'd like to know too, maybe he has restless legs or hemorrhoids or probably a bad back. Makes you wonder if he sits down for dinner. These people are who? Maybe he sleeps standing up. No, I'm not a horse.
I like this.
This guy said, I fell asleep in the dentist chair yesterday. I could do that. I could almost fall asleep in the dentist chair if they would quit talking to me. Right?
Like when they talk because your mouth is open.
Absolutely. Yeah. You got your hands in my mouth and you want me to talk to you.
Yes. Okay. Dive.
Who's here? Lawyer. She brought her coffee. Or OJ. I'm not sure what that is.
The Michael Jackson?
No, Fabius.
Counsel, you ready on Jackson? Come on up. No idea where he's at?
No.
All right, go ahead and put your appearance on.
Under served by Council Member PK 7788 on behalf of Mr. Mike Smith.
All right, unfortunately, he was scheduled today at 10:15. It's now 10:33. We'll just set him up here and hope he shows up. All right, have a good day.
Forward from what we got. No.
Hard. Maybe that's what I was going for.
Thank you.
What are we wearing?
Yeah, he was direct. He had pinstripes. I like pinstripes too.
Oh, okay.
That was a pinstripe.
And what was the occasion that you remember?
So the
Oh.
that guy did probably in the 80s, early 90s. Yeah. But yes, pinstripe sleeves.
So do you have your check office?
Right here.
Not been updated since here.
Well, I mean, I think yours is probably the same as mine, but I didn't see the from
Between the two of us, we've been checking it all.
Yeah.
Yeah, I mean, I have what you guys have. I'm just wondering if anybody else checked in.
I don't know. I can go check that. On the other minute.
There's not much chance I'm gonna make lunch today, is there?
No, because you have we have 11:15 trial. And a 11 o'clock motion hearing with Miranda.
Something on that.
Good go see.
Oh, yeah. I remember seeing it. I just don't remember what it was. Oh, yeah, that's the 10-year-old case.
Yeah. Now, I want to see if it did me because it wasn't Mohammed that did it. What's the distancing that had to be?
So this is
They'll tell you.
Yeah. Well, when Mr. Renata first gets in, he goes, is there a fellow prosecutor in here?
I think he's pretty much done with his docket now. So
It was written by them. You need to give a copies to your prosecutor.
that was this morning. So yay, Judge. Good to watch you catch up with you a little bit. That was a lot of fun. Let's see if we have anybody else we can watch while we're waiting for the jury to figure out which box to check. Judge Boyd is doing her court, just the same old. Let's see if we got anything from Thurston. Let's see. Kansas. Do we have Mr. McGear? Let's see if she's here.
I'll just take the darn tootin' attorney.
All right. Are you going to hire one? Are you able to hire an attorney?
Nope.
Nope.
I don't have a job.
All right. Fill out. The officer should have an application for court-appointed attorney. Fill that out
We got
Oh,
motion.
you
We got
leave.
motion. Hold, please. Everyone standing. Let's see what's going on here.
Court, all rise. Daughter Cohen's back in session. You may be seated.
On the record, Your Honor. All right, the jurors have a question. Basically, they are asking, what are the 3 criteria for assault and battery and the 3 for strangulation? So, Mr. Clerk, if you'd mark this for identification, my intention would be just to re-instruct them on the 2.
Oh, my goodness.
No objection for the Commonwealth?
All right. No objection, Your Honor.
A for identification.
All right, we're ready for the jurors?
Yes, Your Honor.
Mr. Clerk, can I have the tissues somehow?
These jurors, this jury, there may be some Patriot fans on the jury. They read it. It was in the jury instructions. We heard it together. Remember when the judge said the 3 things that were needed? Let me get my brown paper back. Oh, my goodness. We have a question from the jury. What are the elements of the charges?
Jurors enter and all rise.
Took an hour to get this far.
May be seated. All right, jurors, I did receive your question, which reads, what are the 3 criteria for assault and battery and the 3 for strangulation? So let me begin with the assault and battery. The defendant is charged with having committed an assault and battery upon Mila Adams. In order to prove the defendant guilty of committing an intentional assault and battery, the Commonwealth must prove 3 things beyond a reasonable doubt. First, that the defendant touched the person of Mila Adams. Second, that the defendant intended to touch Mila Adams. And third, that the touching was either likely to cause bodily harm to Mila Adams or was offensive.
That sounds familiar,
To prove the first element, the Commonwealth must prove the defendant touched Mila Adams. A touching is any physical contact, however slight. A touching may be direct, as when a person strikes another, or it may be indirect, as when a person sets in motion some force or instrumentality that strikes another. To prove the second element, the Commonwealth must prove that the defendant intended to touch Mila Adams in the sense that the defendant consciously and deliberately intended the touching to occur and that the touching was not merely accidental or negligent. The Commonwealth is not required to prove that the defendant specifically intended to cause injury to Mila Adams. To prove the third element, the Commonwealth must prove that the touching was either likely to cause bodily harm to Mila Adams or was offensive. A touching is offensive when it is without consent. The defendant is charged with strangulation, and to prove the defendant guilty of this offense, the Commonwealth must prove 3 things beyond a reasonable doubt. First, that the defendant intentionally applied pressure on the throat or neck of Mila Adams. Second, that the pressure was substantial. And third, that the pressure interfered with the normal breathing or circulation of blood of Mila Adams. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant intentionally applied pressure on the throat or neck of Mila Adams. The Commonwealth must prove that the defendant consciously and deliberately intended the touching to occur and that it was not merely accidental or negligent. You may examine any evidence regarding the defendant's actions or words and all the surrounding circumstances to determine whether the defendant intended to apply pressure to the throat of or neck of Mila Adams. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the pressure was substantial. You may consider evidence, if any, about how, where, when, and for what duration the pressure was applied, as well as any evidence of its effect or impact on Mila Adams. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that the pressure that was applied interfered with the normal breathing or circulation of blood of Mila Adams. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of the elements beyond a reasonable doubt, you must find the defendant not guilty. With that, I will send you back to your deliberations.
All rise, jurors can step down.
And with a minute or an hour and 8 minutes on the clock. Begin deliberations.
Court stands in a recess.
Can I just tell you? This is not a good sign. It's not a good sign for Mr. Diggs. Because it means that they believe the first witness. It means they have to have believed the first witness to get this far, to say, the only witness, you can't count the officer telling you that here's the report that we got. That's not testimony as to what happened. The only witness that said what happened was the alleged victim in this case. And she lied. She omitted things. She lied about things. She refused to answer questions on the stand. I don't know how you could get a witness on the stand and believe part of what they say after that type of demeanor. 19 times she wants to blurt out stuff that's not appropriate. 19 times the judge has to say, ma'am, answer the question. Don't add on extra stuff at the end that's not appropriate for court. How many times do they have to say, strike that, strike that, strike that? You will not consider this. You can't consider that. It's not for you to consider. And here we are with the jury going, yeah, maybe. I think they did it. I think the state just knocked this one out of the park. Clear and simple. No photos of bruising. No contact with anyone else that she said this happened to. Jubilant, joyful behavior immediately after the event. Even going through next days recorded on video. A clear, and I think an obvious, in my opinion, an obvious pattern of gold digging, attempting to find money, to seek money in this situation. And then you've got one guppy police officer who sees a woman in the lobby and believes everything she says, attempts 2 phone calls, doesn't get an answer, and files charges. And here we are. I think one person is confused, needs clarification. Maybe. I think the $100,000 hush money was indeed not struck from their memories. That isn't for us to decide right here. Obviously, Tiffany C. I wouldn't be surprised if it happened. But the jury shouldn't be considering it. They really shouldn't be considering that at all. She okay, clever name. She ain't messing with no broke. Right. She fraudulently submitted the same receipts for reimbursement, proves her dishonesty. She also filed for payment for wages earned that she'd already been paid for. She claimed that. She denies knowing what her lawyer is doing as far as demanding $5.5 million from Mr. Diggs, that doesn't pass the sniff test, right? We are back to waiting. Let's see what Judge Webster's doing for a second.
But you'll still be found guilty, but the record will show you pled no contest. And then you'd be $183, and I'd give you some time to pay that.
So eventually I need to pay that, right? $183?
Well, yeah, it'd probably be a $75 fine and 108 court costs for a total of $183. Which, for another $100, you could take the diversion and keep it off your record. It's up to you. I can give you time to think about it, to try to talk to an attorney and come back if you want.
I don't know. I'm a little bit worried. Yeah, maybe I would go for diversion, but yeah, I was thinking like, could you reduce the price a little bit, like the fine a little bit?
Well, if you're found guilty by plea or conviction,
then they can't.
I will probably stick to that scheduled fine and court costs. Now, you may be able, I don't know, Miss Gillette, the lady on the screen is the county attorney. Diversion is her program.
Clock's on the screen.
She may or may not negotiate with you on that diversion fee. I don't know. But you'd have a chance with her that you wouldn't have with me, because I'm pretty well stuck by those scheduled fines.
What's your bottom number, Judge, that you'll accept?
But if I set this over to July 17th, that'll give you time to talk to the county attorney about diversion, to prepare for trial, or to come back and enter a plea if you want to. A plea of guilty or no contest. I don't want you to feel pressured to do this. I don't want you to feel like, gosh, I got to make a decision right now, because I'll give you time, clear up till July 17th. That's what, 2 months, May to June, June to July, and then a little bit extra after that even.
Okay, ma'am, I will pay for the diversion right now, like after this one. Yeah.
So after court, you're going to go down and pay for diversion?
Yeah, because I'm an international student, so I don't want to like take risks. I don't want to put anything on my record. Yeah.
Okay. So Miss Gillette, is that all right if he goes down to your office while he's in the building?
Yes, they're there.
Okay, Missy, what date of July 17th? What time?
11 o'clock.
All right. Now, if you're not fully diverted by 11 o'clock on July 17th, you need to come back by Zoom. Appear again by Zoom, but you can apply for and receive your diversion before then. But make sure you are fully diverted and complied with your diversion before you just skip court.
I got the email, the mail copy for the diversion.
Okay,
I'm not sure, like.
To go for diversion, go out there and tell the security officer that you need the county attorney's office, and he'll lead you down there.
Okay, thank you.
You're welcome. And you can finish your paperwork and give them the money. Make sure they explain to you what you need to do, though, so you don't get into any trouble by not appearing July 17th at 11.
Okay.
All right. Thank you, sir. You're excused at this time.
But Judge, I have Orlando Patton here.
Where did you find Orlando Patton? Is he on the docket?
Yes.
He is. All right. Great. But not Joshua Patton. We did Joshua, didn't we?
Yes.
Okay.
Oh,
Good afternoon.
good afternoon.
We are on the record in GW 2026 TR 231, State of Kansas versus Orlando Lloyd Patton. County Attorney Jill Gillette appears for the state. You are Mr. Patton?
Yes, ma'am.
Okay, Mr. Patton appearing in person and pro se.
Yes, I tried to do the Zoom thing. I'm not good with any of that. And I couldn't get anything to pop up on my phone. And I called my bondsman when I got stopped. And I'd be on top of everything, let him know. And I said, well, I'm going to get here. And then I just was sitting here. And then the Zoom thing pops up on my phone. I'm like, well, if I would have went off of that, I would have missed something. I was not going to miss this.
All right. Well, it looks like you're appearing because you had a citation and notice to appear on count 1, driving while your license was suspended. This is a Class B misdemeanor. The penalty is anywhere from $100 to $1,000 in fines and up to 6 months in jail if you don't have any prior convictions for driving while suspended.
Yes, ma'am.
And in count 2, one-way glass or sunscreen device under 35 degrees visibility. And that's an infraction up to $500 fine and 30 days in jail. Those are the extreme possible penalties. Count 3, driving without proof of liability insurance, a B misdemeanor. The penalty could be anywhere from a $300 to $1,000 fine and up to 6 months in the county jail. Now, because there are some misdemeanors in here, you do have the right to not only hire an attorney, but apply for court appointed if you cannot afford to hire an attorney. So, are you able to hire an attorney, or do you want to apply for court appointed?
Probably would have to with it because I'm on disability and my funds are limited because I'm had been moving from Springfield, Missouri to Wichita, Kansas. And me and my mother and stuff are still trying to get set up there. And I was on my way. I thought I had that stuff taken care of, but
he's a talker.
I didn't. It's been so much going like back and forth trying to get stuff taken care of. So my insurance, my brother got us on that because he's good on doing it online. And he has it on his phone. I thought I would get the paper in the mail before my court date, but I hadn't got it. So
are you wanting an attorney that can help you with this, kind of navigate through this? If you want to apply, are you employed?
No, I'm under disability.
Okay, you did tell me that. All right.
Yes,
well, if you want to apply for court-appointed attorney, the officer should have an application for you to do that before you leave. Also, if you want to go down the hall the other direction to the county attorney's office, they can tell you about diversion where you might get these dismissed and keep them all off your record.
He's not diversion eligible.
Oh, he's not diversion eligible? Well, forget that then. I'm sorry. So all the more reason you might want to look at it for an attorney. So have the officer give you an application for attorney. Fill that out before you leave. I'll see if you qualify for court-appointed attorney, and we'll go from there. When's his next court date, Missy?
These wouldn't.
July 17th at 10 a.m.
You must be back here by Zoom, July 17th at 10 a.m. What was your question, sir?
I just was thinking that these would have been a fine I probably could pay.
Better talk to your attorney about that. No, it's not just a fine you can pay and they go away.
Nope.
I mean, they could end up in a fine, but there's also jail time possible. other considerations that you might want to talk to your attorney about if you get one. So if you want an attorney, fill that out, leave it here, but don't go away until I find out.
Got some motion, went up to the ceiling here in court. We have audio. I'm going to play the music. I think we've got a verdict.
Will the jurors and the defendant remain standing? All others may be seated.
Yep. Called it after 10 minutes of deliberating after they heard the instructions on the elements of the charge. The jury, with 1 hour
Madam Forelady,
20
has
minutes.
the jury agreed upon a verdict?
Reach a verdict.
Yes. On count 1, strangulation or suffocation, what is your verdict? Guilty or not guilty?
Not guilty.
On count 2, the charge of assault and battery, what is your verdict? Guilty or not guilty?
Not guilty.
Boom.
Madam Forelady, members of the jury, hearken to your verdict as the court has recorded it. Upon your oath, you say that the defendant is not guilty of the count of strangulation or suffocation and not guilty of the count of assault and battery. So say you, Madam Forelady?
Yes.
So say all members of the jury?
Yes.
All right, thank you. Jurors, please be seated for a
tearing up.
moment. Everyone be seated.
He's tearing up.
Jurors, I told you during this trial and in my instructions that the verdict was your responsibility and your responsibility alone. Jurors, I want to thank each of you for your careful attention and your service throughout this trial. This case has involved a heightened level of public attention. Despite that, you have remained focused on the evidence presented in this courtroom and the law as I instructed you. That is exactly what is required, and it is essential to the fair administration of justice. I recognize that serving as a juror in any case can be demanding, and in a case such as this, it may have required additional patience and sacrifice. The court is grateful for the seriousness and integrity with which you have carried out your responsibilities. Now that your service is complete, you are free to discuss the case with others if you choose, but you are not required to do so. You should not feel any obligation to speak with anyone, including members of the media. If you are approached, you may simply decline. Whether or not to speak is entirely your decision. All I can say is that on behalf of the court and the parties, thank you again for your public service, and you are now excused with the thanks of the court.
All rise, jurors, and step down, please.
As the jurors leave, he was literally seconds away from finding out if he was going to spend months or years in prison.
Stefon Diggs, sir, you've been found not guilty on the following charges: strangulation or suffocation and assault and battery. Such charges will automatically be sealed by the Office of the Commissioner of Probation and the Clerk's Office, unless you notify the Commissioner of Probation in writing within 10 days that you do not want the charges sealed, using the request not to seal court records under General Laws Chapter 276, Section 100C form, which is available on mass.gov. The request not to seal form must be sent to the Office of the Commissioner of Probation by mail or email to the addresses provided on the form. If you want copies of any documents associated with these charges, you must request them immediately before the charges are sealed. Once the charges are sealed, you will not have access to related documents unless you file a motion with the court asking to unseal it.
The lawyers will handle that.
Sir, you've been found not guilty. You're free to go, sir. Thank you, Your Honor.
You're welcome.
Court, all rise.
Just all media, you can step outside now, media, please.
There we go. Hugs all around. Congratulations to his lawyers.
This court stands at a recess.
The bailiffs really take their job seriously.
Step outside now. Okay.
Thank you. Appreciate it.
Thank you.
And they're being kicked out. So there we go. Wow. I believe that was the right verdict. We had major credibility issues with the one witness that claimed there was an assault. And as much as I want to believe everyone who claims that something happened, I just could not on this one. I just could not. It was not there. So, wow. With that, it took us to 4:30. I was nervous. Massachusetts, you put me right on the edge of my seat. I was worried that it was going to go a different direction. So. That's for family, and out he goes. So, all right. She lost the case by herself. She did, 100%. And it came across as being completely fabricated. A grab for money, a grab for clout, revenge, and it was just not right. So glad the jury saw through that and reached that verdict, because I think that was the right one. All right, with that, we're going to wrap up for the day. My headache is not going away, so I'm going to call it right here.
Hello.
Let's see. Got verdict music. I knew as soon as it was a 10-minute delay between the first question and when they came back that we had a verdict. No cold hot dogs for you tonight, Mr. Diggs. Eat some steak. Have it cooked by a good chef. Guys, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning. We're waiting for another Ohio case to come around. We'll find some more trials to watch. Keep you updated. You can DoorDash. You can do something. Y'all, thanks for being here. I appreciate it. Appreciate all of you. Hope you have a wonderful evening. I've got somebody calling in right now. Hang on one second.
Call from
AWOL.
Hey, AWOL, what's happening?
What's up? Oh, man, you played the music?
Yeah, you're behind.
Wow, that was quick.
You're behind times. Already signed off.
Am I? Oh.
No, you're good. What's on your mind?
Nothing. What are your overall thoughts? Do you think the DA should have even brought this up?
No. There was
right?
no corroboration of any evidence. There was nothing.
Because it was only her statement, and I guess the officer took her statement down, right? But there was no investigation. He didn't take pictures.
There was no pictures. There was no witness that said, yes, she told me when it happened, or I placed this call, or I called 911 and then I hung up, or there was nothing that could place that in time. And then the effectiveness of, had he done a little bit of investigation, he would have found the same thing we heard today from Mr. Diggs' side, right? He would have heard that here was his schedule. Here's what happened. Who was there that day? We've got the masseuse was there, and we had the IV person was there, and we had mom in the room, and the brothers were there, and she cooked a hot dog with mustard on it, and we would have had all this information put together, and you'd be like, does this add up? If you look beyond the blinder view that the complaining witness provided to police, and just backed up one text message. Just one text message back, and he's like, hey, I'm going to pay you for everything. Thanks. I really appreciate you cooking for me, all this season. I'm sorry it went down like this. Good luck to you. That's how you're going to base it. She cropped that down to be as narrow as possible, and that officer, who probably has never, I don't know. I want to say something insulting to him, and I shouldn't.
Yeah. No, I know.
But you hear me, right? That officer saw that situation and was the knight in shining armor for the weeping woman, who was like, I just need to talk to a woman. Nope. She wanted that, I think. And that's my opinion. I just think that she used that situation to her benefit to file that report, and he ran with it. He bought it hook, line, and sinker. I'm not saying he's gullible, but it looks that way. I just
okay, but this is my question. I don't technically, I don't put the onus on him because he took a report. Now,
well, that was the right thing to
I'm driving
do.
My truck.
He should have taken the report.
Right. So my question is, he took the report. I don't think he was the end all be all. He took the report. He had to have given. He was working the front desk, right? No shame. He was at the front desk. He took her report. Did it come out in testimony? I'm driving my truck. I'm watching so many trials and so many things that did the state say or the defense say that he took a report, handed it to this investigator? I know they said something about 2 days later they went back and filed the charges. What happened within those 2 days? Who did he give her report to that looked it over and said there's probable cause here or there's enough RAS?
He just forwarded it. He forwarded it on to the district attorney. He filed it.
And the district attorney said, let's do it.
Yep. We've got charges.
Not expressing charges.
We've got a high profile celebrity trying to get away with a crime. Is how it looked.
I said this in chat. Oh, I said this in chat earlier, and again, this is an opinion. This is not factually based. This is allegedly. This is just an opinion. Imagine this. I love the system of justice, and it needs to be fair, not only primarily based off the government and the district attorney and the state, because they have an ethical duty that if you feel that a case that you want, if you think you're going to bring somebody to trial and charge them with something, it shouldn't be flimsy because you are the government, right? A defense attorney can go as hard as he wants for his client, right? But the government should have an ethical duty when it comes to the law. Now, if you think about this, if the DA or the prosecutor's office said, I don't see enough here, she just has to do a media tour and say, because of who he is, they didn't believe me. And it's believe all people, right? Hashtag me, whatever. And then it just looks bad for the state. So I wonder if they said, listen, you know what? Let's just bring this up. None of the evidence is going to work. And he'll be found not guilty. And we look like we did our job.
I don't think so.
So because I don't like it. You don't think so?
Their job was to investigate. And I'd say if they took this and said, nah, we don't believe that, I would say that would be wrong, both for the police officer and for their job is to investigate. But you don't investigate during a court case. This is not a fishing expedition to see if there's any charges here. We'll file them and see if it sticks, and along the way, we'll look for facts. That is the wrong way to do it. That the investigation has to come first before the charges come. Before the charges come that can ruin someone's life, right? It can ruin them financially. It can. I don't know what prospects Mr. Diggs had that may not have developed because this was pending over his head. Okay? Look
Advertisement,
at that. Yeah, you've got customers, clients that are like, it could go badly for you, and we don't want to be associated with that. You don't do that. You don't just take this word of one person without any corroboration at all, and run with it. I mean, she couldn't even figure out how long she was supposedly held in a chokehold. She didn't know.
And face to face, and somehow he reared. I'm not going to say the word. Rear NAKED choke. Right? How did you end up in that? But I hear what you're saying. But you're a good person and you have a good heart. And I would like to believe that I do too, that we would go, I would never bring these charges up as a district attorney, right? But again, if we don't do this, we look like we're defending a famous person that has money. So we might as well just do it. I don't like it. I think it's
here's where I stand
unethical. I don't like it, but I think they might have.
I realize that the optics might have looked bad. But in these positions, you've got to base your decisions on something other than will this affect my election next time around. You can't just be like, what does the people want? This is the populist vote. The mob will call for blood at the slightest hint of a problem. That's not the right way to do it. You've got to have sound principles that you're following, principle-based decisions. In prosecution, in investigation, you've got to be looking for the truth, not just for a win or a verdict or a check mark or one more person behind bars. It's
100%. Again, but that's because you're a good person And we would like to believe that everybody in the system is good, but then you get a alleged Aunt Bev.
The two of
and
us
then
are
you
good.
look at it and you,
We're both of us.
well, I would like to believe I'm good, right? But who knows? Only others can say if I'm a good person or not. I can't. That would be ego tripping if I was like, I'm the best. I just hope that I am. But with that thought process, just because we think that we would hold those ethics and morals doesn't mean that others will, right?
But we can hold them to account.
Yes, we could hold them to account, or we could just say, "Hey, it's water under the bridge. Nobody's really going to do anything. What are we going to do? Are we going to fire? Is anybody going to petition the state for Stefon Diggs? No. So if he was a nobody, I wonder how this would have went, which is scary. And hopefully, there's people like you and good people that this doesn't happen, and it's scary.
I always put my faith in the jury at the start of the trial, and I lost it there at the end. I'm like, their question threw me, right? But I would have hoped that even if the defense had not provided any testimony whatsoever and just rested as soon as the state did, that the jury would have found the right conclusion there, because it just didn't add up. I mean, we had conflicting testimony from the one complaining witness, and even the way she described it didn't work, like physically, like the physics of it isn't there. Science can't get us there. So, hey, I have to say,
anyway,
you missed it, but I've got a really bad headache, and I was trying to wrap up when you called. So
all right, I'm so sorry. Thank you. This is my monthly call. I keep it on one time a month.
Awesome. Appreciate it. Drive safe, my friend. Good to hear
all
from
right.
you.
Yes, sir. Take care.
We'll see you.
All right.
Bye.
Bye.
All right. We were playing the music when we were leaving, so we'll do that again. There we go. Call 100 times a month. I missed a call from Ayden. Maybe he'll call back after the show's over. But all right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning. Greeners is sending me these pictures because I left Mod Chat open so he can control what goes on the screen. All right. You guys are wonderful. Have yourselves a great evening. We will see you in the morning. I think that's it. Oh, Taco Tuesday. Have something fun. My family watched Star Wars yesterday. Like almost all of them. I think they watched 15? I forget how many Star Wars movies there were. They binge watched Star Wars yesterday. And then tonight we're doing nachos for dinner. So I'm going to go out and have some of those. You guys have something fun. We'll be back in the morning. As a warning, next time is not safe for work. Oh my goodness. Red, I missed what you sent before. I only saw the scary face. Let's see where that was. Oh, I've got Big Bird. I've got Sesame Street happening. Yeah, good stuff. You guys have a great night. We'll see you in the morning. Bye-bye.
Thank you, sir. You're my new best friend.
What more do you need to see?
There's nothing in the order that restrains you from talking to cats.
Thank you.